Good afternoon, committee, everyone else. It's Wednesday, March 6th at 1 o'clock. This has, or well, it's not 1 anymore. It's a little after 1:30, whatever. Wednesday, March 6th for the House Judiciary Committee. Delegate Stein, if you want to come on up with House Bill 1146. And yes, please. Yes.
Good afternoon, Mr. Chairman and committee members. This bill is House Bill 1146. It deals with indemnification provisions in real estate contracts. Since 1974, we've had a law that says in various real estate contracts, it's against public policy for one party, the indemnitor, to indemnify the other party, the indemnity, even if the indemnity is 100% negligent. Maryland is one of 45 states that have enacted anti-indemnity language associated with real estate contracts. And Maryland and the other states have done this to prevent the party with the superior bargaining power from taking advantage of the party with the inferior bargaining power. But the current law has a loophole in that it says that, or the current law applies to the alteration, repair, or maintenance of a building or structure, but the prohibition of indemnification does not apply to the management or operation of a building or structure. So this loophole is unfair. The first party should not have to indemnify the second party whenever the second party is completely 100% negligent and the first party as a result has zero responsibility, 0% negligent. And whether or not this prohibition of indemnification is unenforceable should not be based on the type of real estate activities involved. So this bill, House Bill 1146, would correct that loophole by saying that the prohibition on this type of indemnification applies to the management or operation of a building or structure. And just to amplify a little bit on this issue, 23 states, not including Maryland, have enacted anti-indemnity statutes in the real estate context that are considerably more stringent than Maryland's law. Those 23 other states also prohibit indemnification in real estate contracts when the first party, the indemnitor, is required to indemnify the second party, the indemnity, and the first party is partially negligent. So anyway, so for all these reasons, Mr. Chairman, urge approval of House Bill 1146. Thank you.
Thank you, Chair Clippinger, Vice Chair Bartlett, members of the Judiciary Committee. My name is Jay Radov. I'm a lawyer and small business owner, and I'm here today in support of House Bill 1146. I'm on the Finance Committee of the Condo Association where I live, and I've been asked to review our management agreement. Our management agreement currently says that the Condo Association must indemnify the property management company for damages arising out of the management, operation, or maintenance of the condo association, unless the property management company is both solely liable and grossly negligent. So here is my quick hypothetical example. Our property manager is late for a meeting. He gets in his car, he gets distracted by a text from his spouse. He inadvertently runs a red light and he T-bones a minivan with 6 occupants, all of whom are seriously hurt. A jury subsequently awards those 6 occupants collectively $15 million. It could be any number, but I'm saying just let's say $15 million. Here's the question. Does the condo association have to pay that $15 million to the property management company pursuant to the indemnification clause in the management agreement? The answer is, it depends. To be specific, the answer is no. The condo association need not pay the $15 million to the property management company if the purpose of the property manager's meeting was the alteration, repair, or maintenance of the condo association. Why? Because the current statute outlaws such indemnification. However, if the purpose of the meeting of the manager was about the management or operation of the condo association, then yes, the condo association has to pay the $15 million to the property management company, even though the condo association did absolutely nothing. But this bill would close that anomaly and loophole. Thank you.
Thank you, Mr. Chair. And thank you, Jay. I know we've spoken about this, and I had a similar analogous bill that I've introduced, which I've since withdrawn because we're still trying to work with Department of Transportation, dealing with indemnity and duties to defend, but it deals with state contracts, not with property management, private contracts. In this case, this is a contract between two private entities. Is that right?
Correct.
And what you're saying is that you can't allow, it's against public policy to allow indemnification if it was negligence, regardless of whether the contract says that. Is that fair to say?
No, what the current law says is that if the indemnity, which is the property management company in my example, is 100% negligent, and the condo association or the indemnitor is 0% liable, current law says that that contract is void and unenforceable, is against public policy if it deals with inspecting, engineering, architectural, alteration, repair, maintenance, construction of real estate, but not if it relates to the management or operation of a building.
So, and you want to make it so that it's against public policy if it's for any,
Covers the management or operation as well. I really only want to add two words.
Right. So basically, if they're doing anything at all related to the association, but they're in their capacity as a professional, but
they do the books. For example, they do the books for the condo associations. So if in my example, if the property manager is going to a meeting with the accountant, and this happens, that's not a maintenance issue, that's a management issue. Or if there's a question about a late payment by a condo owner and it's an operational issue, that is not prohibited by the statute. It would be if this bill passes.
Well, the last question is, would this set a precedent in other areas of the law so that other groups are going to come in and ask for this kind of treatment based on what you're doing? That's an issue that we've had in the past where there's a concern that this may actually open up a floodgate.
Well, let me answer that in two ways. I practiced law for 10 years, and then I ran in insurance entities for 27 years. And I used to advise landlords and real estate developers on insurance issues. I've probably reviewed more than 100 leases, and I never recall a case where a tenant was required to indemnify a landlord when the landlord was 100% liable and the tenant was 0%. So I don't see that as opening floodgates. And as Dana said, 23 other states go further. In fact, some of them go much further in prohibiting these type of indemnification clauses. For example, if the indemnitor is 1% liable and the indemnity is 99% liable, that's fine in Maryland, but it's not in 23 states. 23 states say even that is prohibited. You can't do that.
And Delegate, if you don't mind, if I could follow up, and sort of this is a way to slip in one sentence of my testimony that I forgot to mention. I know in the fiscal note, there are a few state agencies that express concern about, well, if they have these types of provisions and they're now outlawed, it might increase their costs. So we would be fine with amending the bill to say that it only applies to private sector contracts.
Thank you, Mr. Chair. Could you just walk us through the example you gave before, which I think was based on current law, and what would be different if we had the same situation again if we pass this?
Okay.
So I can get a visual.
Okay, the case is a property manager for the condo association. He works for the property management company. He's going to a meeting. So he's working in the scope of his employment. So it's respondeat superior vicarious liability. Anything that the employee does that's negligent goes to the employer, the property management company. So he gets distracted by text. He runs a red light or a stop sign and he T-bones a car, and people are very seriously hurt. And there's a significant monetary reward. The way the statute reads now, it only prohibits a bunch of things. You can look at the statute: the construction, the alteration, the repair, the maintenance of a building or structure. So if the purpose of that meeting was to meet a plumber about a problem under the concrete with a plumbing, then the contract, that provision of the contract is unenforceable, because the statute says that if it concerns the alteration, repair, or maintenance of a building, and the property management company is 100% liable, and the condo association, which isn't even in the car, is 0% liable, that's void as against public policy. So in that case, the condo association has no liability. The contract, that contractual provision is overridden by the statute. But if the purpose of the meeting is not to meet a plumber, but to meet a finance professor about an idea for investing some of the funds of the condo association, or the accountant about an accounting issue, or to go to a board meeting where they're going to discuss late fees, and should we charge late fees to members? What do we do with members who are misbehaving in some way? That is not prohibited by the statute, because the statute doesn't cover the management or the operation of these real estate contracts. It only covers the architectural, engineering, inspecting, surveying services, construction, alteration, repair, or maintenance of a building or structure, or the moving, demolition, or excavating. Covers everything except management and operation. And property management agreements between property management companies and condo associations, and there are hundreds and hundreds and hundreds of thousands of condo associations in Maryland. The way the contract reads is the services provided by the property management company to the condo association are for the maintenance, operation, and management. Actually, it says management, operation, and maintenance. That's the exact language. I hope that helps.
Yeah, that does help. Thank you.
Delegate Schmidt.
Thank you, Chair. In your testimony, I see the written testimony kind of explains what you talked about in your oral testimony. I don't see where the realtors have weighed in or property management associations. I see it, and a lot of your examples regarding real estate. I don't.
Well, that's what the statute
Even with reading the bill, it doesn't really talk too much about real estate.
Yeah, it does, because it says a covenant, promise, agreement, understanding, in connection with a collateral contract agreement relating to architectural, engineering,
Yeah, I can
inspecting-
read it.
Right, or the construction, alteration, repair, or maintenance of a building. So there is, I practiced law for a long time and knew about this, but never looked it up. When I finally was asked to review our contract, I went to the internet and looked at a law firm which has put together a list of the 45 states, actually of all 50 states, and where they stand on this issue. And everything you see on this issue is real estate, real estate, real estate, real estate. Really, they're talking about real estate construction, but almost all of these 45 states, and I can get you this article if you want to. I have a PDF of it. I gave it to Delegate Stein before I asked him to introduce the bill. It's all really limited to real estate construction and related issues.
Thank you. Appreciate it.
Sure.
All right. Seeing no further questions, just making sure that the third delegate from the 11th district didn't want to. Delegate Pasteur. I mean, you both were, anyway, okay, that concludes the testimony from all three of you are here. You don't have to ask a question, I'm just saying. It's it's all good. It's all good. That concludes the testimony.
Thank you.
Thank you.
That
Committee.
concludes the testimony for House Bill 1146. Thank you. Thank you very much. All right, 1178 is next with Delegate Hornberger, please. Apologies, Delegate Pastor.
Thank you, Mr. Chair. Can I bring up my panel?
Yes.
You guys want to come up? Oh, right. Okay, thank you, Mr. Chair. Vice Chair Bartlett, members of the Judiciary Committee, for the record, Delegate Kevin Hornberger here with HB 1178, handgun permit holders, authority to carry handguns in state parks and forest. This bill seeks to prohibit limitations on lawful carry permit holders from exercising their right to self-defense in state parks or state forest. Such areas do not fit the sensitive places criteria applied to other areas where firearm carrying is limited. I would draw your attention to Kipke versus Moore, recently being adjudicated. Additionally, in a more practical sense, such areas are often remote and secluded, leading to an increased need for self-defense in the event that there is a bad actor in the state park. And we had one of those recently in Hartford County. The bill also includes a provision to clarify that this bill does not allow poaching or otherwise unlawful hunting of animals with a firearm. In terms of case law, we would draw your attention to the Kipke versus Moore, whereas the state defendants have failed to show that parks are sensitive places. What brought about this bill was that last year, through internal regulation, the DNR determined on their own as an agency that they could prohibit the carry of firearms for concealed carry holders. So that's why we're here with the bill today. This is being adjudicated in the Fourth Circuit, and it is our posture that folks should be able to continue to have their Second Amendment rights until that case is decided, dealing with sensitive spaces. So with that, I'll turn it over to my witness panel. Thank you.
Mr. Chairman, Mark Pennock, I'm president of Maryland Show Issue. In the spirit of full disclosure, I'm counsel in the Novotny case, which is consolidated with the Kipke case. This bill will eliminate one of the issues in that case, which are the three Department of Natural Resources regulations that broadly ban carry for self-defense and only for self-defense in state parks, state forests, and state Chesapeake forest lands. That's about 400,000 acres in which permit holders are not allowed to carry. As the good delegate has already mentioned, the district court in the Kipke consolidated case has already held that by no stretch of imagination are 400,000 acres of forest land a sensitive place. So this is a chance for this body to move that aspect of the litigation. And I'm kind of speaking against interest here because we know we're going to win that, because we've had two circuit cases come down since September when that case was initially decided on PI motion, holding that you can't rely on post-1868 analogies or inquiries of a statutory inquiry, because the relevant time period is 1791 when the Second Amendment was enacted and ratified. So that issue is going to have ramifications for the rest of the case. It helps us because the same kind of an inquiry is also present on the other issues in the case. There is just no remote reason that you can ban permit holders who carry in other places on which there are many more people, and keep them from carrying to protect themselves from wild animals and predators of other kinds in 400,000 acres of land. So I would invite the help of this committee to move that aspect of the litigation so that we may proceed on other aspects of that case pending on SB1. Thank you.
Good morning. Thank you for allowing me to come in and testify. My name is Carla Mooney. I'm from District 29C, St. Mary's County. I'm a state director for Women for Gun Rights and also a state leader for Armed Women of America. I stand in solidarity with the ladies of both my groups, numbering many more than myself. I looked at this bill as a opening for self-defense freedom. I am a permit holder and I do like to hike in the mountains and in the wildlife areas here in this community, and the idea that I cannot protect myself knowing that I could be a victim to four-legged and two-legged predators. And I appreciate the ability to be able to enjoy these beautiful lands safely. And I ask that you have a favorable report on this bill.
Thank you, Mr. Chairman. John Jocelyn speaking on behalf of 2A Maryland. I would like to echo the incident in Bel Air and call to your attention an area that I am familiar with, and that is the Northern Central Rail Trail, which is a state park. It extends from Cockeysville all the way up through Pennsylvania. 21 miles of that trail are in Maryland. In most of the areas you run between steep hills, you have no cell signal whatsoever. Access is limited to where roads cross the trail and they could be miles and miles apart. Help is not going to come soon if you get into a problem with an issue with a person who wants to do you harm. The right of self-defense is paramount there, and I've often wondered about the women I see jogging by themselves down this trail if they realize the risk they're placing themselves to. Another area I'm familiar with is the Savage River State Forest. I've hunted out there for years. My wife and I vacation out there. I can tell you that once you cross the first mountain range, you might as well be 200 years back in time. What will happen to you will happen depending upon what you do or fail to do and what you're able to do or not able to do. Being able to defend yourself from a predator, whether it's 2 legs or 4 legs, is important. If you do get to the top of a mountain to call for help is probably half hour, 40 minutes away if you're lucky. Parks are no different than any other place. Predators infest those just as they do the rest of our state. You need a self-defense, know where you are, and at any time. At the present time, there are 182,556 carry permit holders in Maryland. They've established a very clear pattern of evidence that they are not a threat to the safety of the public. They certainly shouldn't be denied their right of self-defense just because it says state park. We strongly recommend a favorable report. Thank you.
Mr. Mohammed, please, for 2 minutes.
This is Galen Mohammed, State Director for the National African American Gun Association. We definitely stand in support of this straightforward, common sense gun bill. No bear encountered in the wild is a teddy bear. We have seen many videos of tourists who think that they are Dr. Dolittle and can talk to the animals, but don't realize the unpredictability of these wild animals. These animals, of course, should be avoided whenever possible. However, in the event of a chance encounter, one may need to protect themselves and or their loved ones. Of course, we do understand that this is not a hunting license. And that's not to mention the possibility of needing to protect oneself and one's loved ones from a human attacker who may be in those state parks. Violent people don't suddenly become nonviolent simply because they're in the park or in the forest. We ask that this bill receive a favorable review. Thank you.
Thank you, Mr. Chair. I have a few questions for the gentleman right here. I'm sorry, I forgot your name. And then the lady, the Women for Gun Rights. Can you tell me what are 2-legged predators?
Those are the kind of violent criminals that prey on people. And I've always identified those people as predators. And those are the kinds of people that we were entitled to protect themselves under the Second Amendment of the Constitution.
All right.
And I'll give you an example of how.
I just want an example of a predator. I know what a 4-legged animal is, but are you saying that are you saying humans?
Humans,
are you calling them
yes.
predators?
Exactly.
Oh, okay. A little bit inappropriate, I think. My second question is, do you want to have your gun for hunting, or what is it that because if you're hiking, maybe a little heavy with your gun. So are you looking to hunt or deer?
Well, no, actually, some of these state forests, for example, allow hunting. They don't allow the possession of a handgun for self-protection. So you could hunt in some of these state forests, not state parks, state forests, fine with a firearm. But you get arrested if you merely travel to a state park with a handgun who's also a permit holder. I have members of mine that have actually been cited by state police and by state park police who are merely driving through a state park on their way from A to B and driving through a state park because they have a permitted handgun on their possession.
Maryland, yes.
Very few.
Few, okay.
Yeah.
Speaking of one last thing, Mr. Chair, as you indicated with one thing and with something quick, as you indicated, there are park police. Do park police not carry? Yes.
Park police certainly do carry.
And that wouldn't be sufficient if an emergency happened?
No, it would not,
Okay.
because park police, and I'll give you an example, Savage River State Park or some of the western area, the park police can't even find them because they're so few in number, and the instances that you need to exercise self-defense, they're not going to be there. They are maybe hours away.
Let me ask you one final question. So let's just say a park that hunts, would you be open to some type of amendment to say that you can only carry, let's just say for the sake of argument, that's not something I support for the record, but I want to say for the sake of argument, if you wanted this bill to pass, let's just say, would you allow only handgun? Would you allow for a permit and to carry your gun in parks that would do hunting? Would you be open to that?
Well, no, for the same reason,
Okay.
because parks are.
Well, you said use it for hunting, so if you want it for hunting, and if some parks do allow hunting in the state of Maryland, would you be open to wanting to have your gun only in parks that allow for hunting?
No, none of the parks, if I recall correctly, allow hunting. It's only the state forests that allow hunting. So the whole point of here is self-defense, and that's equally applicable
Against
to.
the predators?
Well, yes.
Okay.
Yes.
Thank you, Mr. Chair.
So I'm just gonna make sure you guys know about the predator that destroyed a woman in my district, which you mentioned earlier. She was jogging and he had enough time to mutilate her so badly, they did not know who she was for a significant period of time. So no one is coming to save us, isn't that correct?
That's correct.
Yeah, and I would add that I've visited that park. It is not a remote,
No, it's not.
middle of nowhere park.
Nope, it's in the middle of the community.
Much of that park is visible from the highway,
Yep,
has adjacent residential properties.
yep.
And yet what you just described was able to happen. Imagine where we have 20,000 contiguous acres in Western Maryland.
Exactly. Yeah, that case is the reason why children anymore to any Maryland state parks. That is the reason. So this is a great bill. Thank you.
Thank you.
Thank you, Mr. Chair. Thank you, delegate, for bringing the bill, and thank you, panel. First, a comment, the estimate of having someone respond in 30 minutes to Savage River is very generous, being familiar with that particular park and that location. My question is this, and this is to the delegate. You referenced that the department pretty much instituted this policy after the legislation, as a result of the legislation last year. So this was not in effect prior to Bruin in the legislation. This is something that was enacted after as a result of it. If
I think we'd have to ask counsel on that because I believe that in some instances it was.
So my understanding is that it was not part of the SB1 litigation that was passed last year. It pre-existed the SB1 litigation by a substantial margin. So this is actually was legislation that are regulations that existed prior to the Supreme Court's decision in Buren. So it was built on the premise that carry is not a constitutional right, is a privilege that may be denied, however arbitrarily. So that whole premise is now gone, of course, after the Supreme Court's ruling. So it has to be this regulation has to be recognized with reconciled with what the Supreme Court ruled in Buren, and then there's just no way it can survive under the Buren analysis for all the reasons I've detailed in my written testimony.
just trying to confirm that this was their policy prior to that.
That's correct.
And then they've just continued. It wasn't as a result of, they didn't do it just the last year or so as a result of.
That's
You couldn't
correct.
carry in the park 5 years ago.
That's correct.
Okay, thank you.
Delegate Munoz.
Thank you, Mr. Chair. Thank you, delegate, for bringing this bill, and thank you, panel, for coming today. I just have a couple clarifying questions. So first of all, this bill has nothing to do with hunting. Is that correct?
That's correct.
That's correct.
And then my second question would be hypothetically, if I were to take my small children into a state park to walk along the trail, I could not legally carry a gun to protect myself. Is that correct?
Under current law, that's correct.
Even
And-
if you were a concealed carry permit holder.
So with a legal concealed carry permit
Mhm.
and a handgun that I obtained legally, I could go onto a trail with my small children with that gun to protect my family. But a criminal could just walk into a state park carrying with the intent to do my family harm.
And they do.
Yes, ma'am.
Thank you very much.
Yes, thank you, Mr. Chair. It's good to see you all again. This is for the sponsor. Delegate, mental health is something that is very important to me. So I'm just wondering if we pass your bill, are you at all concerned that suicides will increase? Because if I'm depressed, I now can carry my gun into the park and take my life. And The other thing is, is there evidence that I'm well aware of Mr. Pennick's group's litigation, but is there also evidence that when we allow people to carry guns more places, there are more accidental shootings?
Yes, thank you for the question. So the first thing that I would point your attention to is that the assumptions that are out there, the myths that are out there, that folks that have mental health issues are more likely to commit suicide or commit a violence with a gun is a factoid. It's not supported with the evidence. Populations are very similar when it comes to either suicide, crimes with firearms, and the like. It's also not race specific or religion specific. There's no evidence that shows that one cohort is more likely to commit suicide or a gun crime. That's how I would answer the first part of the question. And again, these aren't just average gun purchasers or HQL holders. These are folks that have at the higher bar that have a concealed carry permit. And most of them have been doing so and rigorously vetted by Maryland State Police. So I would push back on the first part of your question. In terms of the second part of the question, again, we're dealing with a cohort that is past rigorous training and background checks and is knowledgeable in not only firearm use, but defense as well as operation. And this group is less likely to result in an accident. Now, of course, there are accidents that happen even amongst the hunting community. And I don't have numbers in front of me, but we tend to see more accidents in hunting, and those are related to cardiac arrest, falling out of tree stands, the administering of the hunting, than we see with populations of just going about daily concealed carry use.
Thank you.
Yep.
Thank you, Mr. Chairman. Thank you, panel. Are mountain lions known to attack and kill humans?
Yes. I actually studied this at some length when I was a scout leader and took my kids out to western parts of the United States. Mountain lions found in Maryland, by the way, are ambush predators. They will stalk and kill from behind with no warning. So you teach your scouts, for example, to go in pairs and be fully aware of what's all around them, simply to avoid the possibility of that kind of attack. But it's not just limited to that kind of attack. Rabies is found in all parts of Maryland, including these parks and state forests. And a rabid animal like a fox or a raccoon, it can quickly attack with very little warning and with very little notice. And you're not going to be able to fend them off very easily. And it's, of course, a bite from a rabid animal will communicate that sort of disease to the human. Unless they're treated immediately, they will die very painfully.
Yeah, and I just want to add, I know that it's easy to surmise about animal encounters and the like, but really I want to draw the focus of this bill back to the fact that this is a Second Amendment right and that we feel that it's being misapplied to state parks. So we could go on and on about scenarios of defense against animals and whatnot, but the impetus for this bill is preserving Second Amendment rights. So that's why we're asking for a favorable report.
Yep. Thank you, Mr. Chair. Just a quick question. Has Department of Natural Resources weighed in?
I don't have access to the floor system.
They haven't submitted anything, but I'm just wondering, have you had private conversations with them?
Yeah, so I met with the secretary earlier this session, and we spoke briefly to this, but at that time they did not have a position.
Okay, thank you.
Seeing no other, Delegate Conaway.
One more question.
Mr. Chairman, thank you, delegate and panel for coming in. I was wondering, do any of you know how skillful the mountain lion is in a vertical high jump?
It's quite impressive.
More skilled than I.
15 feet. Thank you very much.
Definitely a bad kitty.
Listen, thank you. And even before I have my question, I want to thank Mr. Muhammad for continuing to, express himself during these hearings. He's my constituent. And also, I'm not a gun enthusiast. I don't own a gun. So really, this is a question, right? And I know our state parks are there and they attract tourists from all over the country and all over the world. So if I'm in a camper, right, and I am I have a licensed gun holder, what do I do with my gun? Can I have it in the camper and come into the state park, or do we have, like, what happens in that
Well,
scenario?
That there's, but my legal colleagues here will probably back me up, but there is Supreme Court cases where they have determined that even a person that may be homeless, maybe living outdoors, or in a camper or a mobile camper, that is still considered their domicile. And as a result, they still preserve rights in that domicile. You maybe back me up on that.
So it's a kind of an interesting question in Maryland. If you're talking about an RV that goes to park in a state park, for example, that's a harder case to make that as a domicile. Maryland law broadly prohibits people who don't have carry permits from having possession, mere possession in a vehicle. That's 4-203B, A1B. So you really, you're taking a big risk for arrest if you bring a firearm at all into a vehicle and travel anywhere. It's doubly risky if you take it into a state forest or a state park, because you have a regulation that will rely on that. And I know one individual who's a member of MSI who in his camper was driving through Cunningham State Park, was pulled over for a traffic violation. I think he was going a little too fast. And he disclosed the fact he was a carry permit holder. He had a firearm with it, and he still got a criminal citation for it because he was in the boundaries of Cunningham State Park. And he had to pay the fine. Now he was just wasn't even going to be in the park for any other purpose than going from A to B through it. And he still got a citation. You see, that's just crazy.
Seeing no further questions, we thank you all very much.
Thank you, Mr. Chair.
That concludes the testimony on House Bill 1178. We'll go now Delegate Schlega, House Bill 1335,
Great job,
please.
yes. Good job. Thank you, sir.
Thank you, Mr. Chair. Welcome committee, welcome myself to your committee, I guess. I'm usually sitting on the other side. With reference to vertical leap, I would like to point my colleague to JJ Watt for the human with an amazing vertical leap, maybe not 15 feet, but nevertheless, this is Delegate Kathy Schlega here on behalf of House Bill 1335. Reckless and negligent driver, death of another must appear, Sherry and Christian's law. For those of you that have been here, this is not the first time you've heard this bill. You heard it last year, and it's been in for a number of years. As everyone says when they come before our committees, this is a very simple bill, but it is indeed a very simple bill. It is just says that if someone is charged with reckless or negligent driving and their driving contributed to the death of another, that they must appear in court. So currently, if you are unfortunately involved in a vehicle accident, and someone dies and you are just charged with reckless or negligent driving, you don't have to appear. You may pay a fine and not come to court. And there are only 34 or so people per year, fortunately, that fall into this category. And we've added provisions to allow the judiciary to exclude some folks from that category if they feel like, someone would not be safe or be overly burdened with appearing in court. We're giving judicial discretion to say, it's not an absolute must appear. The judiciary is fine with this bill. The state's attorney support this bill, and the public defenders are fine with this bill. I've worked with all of them over the years. There is no opposition to this bill, and it's just a simple fix. And I believe that this will actually bring healing and closure for families that have lost a loved one in an accident, and also for the person that was unfortunately involved in the accident themselves. And with that, Mr. Chair, I'd like to turn it over to my panel.
Good afternoon. Chairman Clippinger, Vice Chair Bartlett, and members of the House Judiciary Committee. My name is Ken Eaton, and I am the Executive Director of ABATE of Maryland Incorporated, a state motorcycle rights organization. ABATE has worked on right-of-way violation penalty bills from 2004 to 2008. In the middle of that effort, Marty Schultz, our then Executive Director at the time, died in an accident where another driver violated his right-of-way and caused his death. In 2008, we successfully passed SB 712 and HB 1231 that established if a person fails to yield right away in violation of specified provisions of the law and the violation contributes to an accident that results in the death or serious bodily injury of another, that person would be subject to a fine and motor vehicles could suspend their license. However, after a few years, after speaking with attorneys that were left with few options regarding right-of-way violation cases, we decided to renew our efforts and try and add the must appear provision to the law. HB 1335 adds the must appear wording, and this year includes the discretion of the court. I have attached a list of many of the current must appear offenses in my written testimony. Failure to report an accident is a must appear, but reckless or negligent driving that contributes to an accident that causes the death of another is not. I think it's past time to add this to the list. On behalf of the Schultz family, the Sherry Zidane family, the Travis Christian Butcher family, all motorcyclists and all motorists in Maryland, I'm urging this committee for the support of HB 1335, reckless and negligent driving penalties. Thank you.
Good afternoon, Mr. Chairman, Madam Vice Chairman. My name is Robert Spanberg. I'm the Chairman of the Board of ABATE of Maryland. As the delegate and my colleague here have told you all, we have been here a number of years trying to get this legislation passed. And I'm hoping that this will be the year. I generally try when I'm testifying before committees about numerous other bills that concern us or we feel that we should be involved with. I try to approach them with a analytical and most times mathematical presentation to try to get my point across. But I try to keep emotions and personal things out of it. But this is a particularly touchy subject. And I just speak from the heart. It feels like a person who is loses their life in a motor vehicle accident, and nothing comes to pass. No one has to appear or state the case or anything. It almost feels like one of those four-legged animals that we were talking about. It's just something you eventually end up forgetting. It's a terrible thing to have to carry as a memory of your family member. Sorry to get emotional, but that's the way I feel about it. I really hope that this will be the year that we can pass this bill, HB 1335, into law. Thank you for your time.
Thank you, Mr. Chair. Since this is the first time I've heard it, please tell me what the opposition to this has been.
So there is no opposition any longer. The first time it came in, I think the courts were a little bit concerned about, how many cases this would involve. But I think in my testimony, it actually says, I think it was like 32 cases last year. So clearly not overly burdensome. And last year, the bill passed out of this 2 years. It's been out of the Senate and come here. So I'm hoping this year there's no opposition, just would be affecting a very small number of families, fortunately. And, too often this could be a motorcycle rider who someone, accidentally runs into the back of them at a stoplight. And, so the families are asking for that opportunity to be able to have their day in court. Purely, I think, a healing and a moment of forgiveness from the family of the victim.
Thank you. Thank you, Mr. Chair.
Thank you. Delegate Greenville. And I love AB, you guys used to come on Monday nights and with a big presence, and I guess it's dwindled down a little bit, but is this because you find that motor vehicles are often hitting motorcyclists, cars are often hitting motorcyclists at a higher rate than they're hitting and potentially killing motorcyclists at a higher rate than in other cars? Is that why you guys are here?
Something I've stressed through the years, and like I say, this has been going on for a while. I don't consider this a motorcycle bill. I really don't. I consider this a citizenry bill. I think everybody has the right to make their lives matter. Personally,
I agree. I happen to believe that motorcyclists ought to be treated equally. So I'm just, if it's something that is impacting you guys, that should be something that should be noted.
I personally don't feel that it impacts us any more than it impacts anyone else.
Fair
honestly.
enough. Good, fair enough. The other, so there's not necessarily an increase in the penalty. It's just a requirement for them to be in court to have to face the family, assuming the family's going to be there or somebody else, or the judge. Is that right?
Yes, there is zero increase in penalty. The only thing that we're changing here in the bill is that you must appear. And again, if the judiciary, feels, if the judge says, hey, not in this instance, we're giving that discretion. But, yes, I would say, Delegate Cardin, I ride a motorcycle and it's innately dangerous. And if you rear end someone at a stoplight who's in a car, they have an airbag, they have a seatbelt, they, have things around them to protect them. But if you rear end a motorcycle at a stoplight, they clearly do not have those protections. And we all know that when we ride, that it is innately dangerous, but it's still a lot of fun if you don't do it. I recommend it.
Thank you, Mr. Chairman. As a fellow motorcyclist, I'm sincerely grateful that you're here testifying. Would you happen to have any data on how many motorcyclists die on Maryland roads annually?
I have no idea. I'm happy to say that, this bill isn't just motorcycles, as Delegate Cardin said.
Understood, but I'm just wondering how big of an impact it's having on us.
To my knowledge, it's the 5-year average is like 74 per year.
Thank you very much.
That's good.
Thank you, Mr. Chairman. Thank you, Delegate, and thank you, panel, for coming in to testify. My question is in reference to page 2, line 11 and 12. Allow the person to enter a plea of guilty and prepay the fine. If you didn't have to appear in court, would you have to plead guilty before you could pay the fine?
So this is saying, after a court has issued a writ summon, blah, 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 the person if the court may for good cause. Yeah, the court may, this is the judicial discretion part. They may waive the requirement to appear, and they may allow the person to enter a plea of guilty and prepay the fine. If you prepay the fine, you're clearly pleading guilty by paying the fine. So I think that's redundant.
So when would they allow you to prepay the fine?
Only if the judge says yes.
When you appear in court?
No, this would allow this section from line 7 to line 12 is the judicial discretion part of the bill that says that the court could allow someone to prepay the fine and not come.
So if this bill passed, you would petition the court to prepay the fine and waive, and they would say either yes or no, you must appear.
Yes, a judge. Yes, exactly.
Thank you very much.
Thank you.
Any further questions?
Delegate Conway's question raised another question for me. And I want to make sure I'm reading this right. So if you petition the court not to appear, is this saying, and maybe this is for somebody else to help me, that you must plead guilty and pay the fine? Or yes. Okay. All right. I just wanted to be clear. Thank you.
I was to say there's an and, so you've got to do both. And yeah, that's
what I'm
I don't think that you could waive the appearance and then plead not, yeah, you couldn't do that because then you would not need to waive your appearance. All right, further questions? Seeing none, thank you all very much.
Thank you, committee.
Thank you.
All right, House Bills, that concludes House Bill 1335. We'll go to House Bill 1166, Delegate Heinebaugh. Is this his first time in front of the Judiciary Committee? All right, and now for your cackles and everything else, now, Mr. Pennack, Mr. Jocelyn, Ms. Moody, come on back.
This
Bring
is
your
almost
panel
like
up.
being back in Vietnam. It reminds you of, you know, so, well,
I'm sorry, did you just describe this committee as a Vietnam conflict? Oh. Okay, well, this
Okay,
is starting well for you, Delegate. Go ahead.
I'm digging my hole deeper and deeper. What can I say? Chair Clevenger, Vice Chair Bartlett, members of the Judiciary Committee. Thank you for the opportunity to present House Bill 1166 for your consideration today. For the record, my name is Jim Heinebaugh. I represent District 1A, which is all of Garrett County and the western part of Allegheny County. I'd like to begin by saying that I submitted this bill on my own. I have introduced legislation on behalf of the county commissioners and the Chamber of Commerce. This I submitted on my own. It was there's no organization, no other people who asked me to submit this bill. I did it based on my own personal observations. I'd also like to say the bill's not about promoting concealed carry. It's more about making concealed carry permit holders aware and better informed about what the laws are that governing the wear, carry, and transport of handguns. So I should also say this bill was cross-filed in the Senate Bill 501, and it passed on the Senate side already. So this bill requires the Secretary of the State Police to publish a handbook summarizing the laws regarding the wearing, carrying, and transportation of a handgun in Maryland. The proposed handbook will help concealed carry permit holders comply with state laws, and I think can potentially reduce violations of the laws. What I'm suggesting is something very similar to what DNR does when you buy a hunting license. When you buy a hunting license, you get a guide to hunting in Maryland, tells you when the seasons are, when you can shoot, what you can shoot, how many you can shoot or harvest rather. Same thing with the fishing guide. And I think personally for something as important as concealed carry, it would be worth the effort to publish such a guide for concealed carry permit holders. The need for this handbook is pretty apparent and it's growing. For example, as the concealed carry laws have changed, more people are applying. I read there were almost 65,000 new applications for permits in 2023. And there are a total of, the numbers vary, but there's about 175,000 active license holders right now. There is a fiscal impact to this bill. In my opinion, the benefits are worth what it will cost. I would add that if the cost becomes a big issue, there would be an option to publish this in a digital form and not necessarily produce a hard copy. Again, it's my personal opinion that I don't know how we can say gun safety and regulations are important if we're not willing to invest in making sure that people know what the rules are. Is that my time up? Okay. Well, can I add one thing, sir? There is a technical error in the bill, the way it's written. Its effective date is 1 October. The book is also required to be published on 1 October. The bill writer is working with the Maryland State Police to kind of resolve that issue. So in closing, I respectfully request the committee's favorable consideration of the bill, and I appreciate your attention and time. Thank you, sir.
For the record, Mark Punick, President of Maryland Show Issue. I'm a licensed attorney in Maryland. I'm expert in Maryland gun law, and I'm about the only licensed attorney I know who's expert in Maryland gun law. and I study it every single day. The case law of self-defense, for example, is all case law. There's no statutory provisions. It is really difficult for people to understand Maryland gun law. I get questions every single day by people who evidence that misunderstanding, and these are permit holders. There are so many regulations out there that people are unaware of. There are so many ambiguities associated with those regulations that people are unaware of. So there is a crying need for this state to step up and educate gun owners about the many laws that this body has passed that restrict their rights to carry a firearm. So I'm in support of this. I think it should be amended in accordance with what the Senate did already and passed this. It passed the Senate unanimously for 46-0. I mean, when's the last time you had a bill in front of you that passed unanimously with bipartisan support? The need is apparent, the cost is de minimis, and there is a very powerful reason to actually do this. Make my life a little bit more easy so people will ask me fewer questions about Maryland's maze of gun laws. I urge a favorable report.
Good morning. Thank you for allowing us to come in and testify for this bill. My name is Carla Mooney from District 29C, St. Mary's County. Again, I'm State Director for Women for Gun Rights and the State Leader for Armed Women of America. I thank Delegate Heimbaugh for proposing this for a written or electronic copy. This type of handbook would be paramount to information giving. As an instructor myself, I teach a lot of classes, probably 2 to 3 a month, plus I have monthly meetings with my Armed Women of America. And I have to say, Maryland's law is what I talk to the most throughout all of these discussions, all these training classes. Our legal section and our training class is 2 to 3 hours for each class. And that's on top of the additional 16 hours we spend with them to teach them the actual gun information. So as an instructor, I think this needs to be done, and it should have been done quite a long time ago. This is a resource that we all need. And if financial is a burden to you guys and you feel like that's why you shouldn't do it, make it electronic, please, because it would really benefit our state and our community. I request a favorable report on this bill.
Good afternoon, Mr. Chairman, members of the committee. John Jocelyn speaking for 2A Maryland. When House Bill 824 was passed, the Maryland State Police were tasked with assembling the gun laws in Maryland. They worked very, very hard on this for many months. I was involved with proofreading some of the things it did, offering comments. My first batch of comments were 7 typewritten pages. They did the very best they could, but still the product needs improvement. As you've heard, there are a lot of questions on what's happening. How do you interpret the laws? Instructors have emailed me asking, well, what does this mean? What does that mean? I believe that we should amend current legislation to place the responsibility with the subject matter expert, specifically the Attorney General of Maryland, to have them develop this package. The current document from Maryland State Police is 71 pages long. 30 of those pages are dedicated to the law. They cover case law, Maryland law, federal law, and pattern of jury instructions. Most instructors have no clue what jury instructions are. I didn't even know they existed until it appeared in the state police document. They don't know how to teach it. What I suggest to you is that we have the subject matter expert, the Attorney General, do the package and provide it to the Maryland State Police. That it be provided in digital form available on their website. At the present time, there are 3,368 instructors. If we do it in digital form, we can also have it electronically converted to another language, because under State Government Article 10-1103, it has to be published in several languages. If you have no hard copy that you have to deal with, the cost is minimal. We believe we can get a better package, better suited to the people of Maryland, to the instructors, at very, very minimal cost, certainly under the current fiscal note. We would ask that you give this a favorable report.
Thank you, Mr. Chairman. Thank you for bringing this bill forward, Delegate Heimbaugh. Based upon your life experience as a Army colonel, Does the military do something similar to ensure safety and compliance with firearms?
I don't, when I was in the military, you weren't required to have a permit, but you did receive extensive training on the use and safety. Oh, yes, we had a field manual. The Army, the military has a field manual and everything. So there was a field manual on weapons, qualification, maintenance, assembly, disassembly, all those.
So you have extensive knowledge on this field in some form or fashion or regulation?
I think I have, yes.
Thank you very much.
Hi, thank you, Mr. Chair. So I have a couple, I'm looking at the Senate amendments now, and I don't know if you had a chance to see them yet. They do mention, the digital form, but they also mention something that I'm not sure about. So when a person receives their wear, carry, and transport permit, do they have to give their email address?
Yes.
Okay, and so are they responsible for keeping that updated to
Yes.
someone?
Yes.
Okay, because in the Senate version, the secretary would actually be responsible for sending out an email every time the handbook is updated to the
Yeah.
license holder.
Isn't that correct?
So,
Yes, that's current law, by the way. That's on HB 824. There is a requirement to educate the gun owners in Maryland. Well, all legislative changes made by this body every year. So state police already have that information. They have it for HQL. They have it for the wear and carry permit.
so they already do this.
Yes.
Every time the law changes, they send out an email?
Well, as of October 1st of last year, yes, that's what they were required to do.
So they're doing that, and actually, I don't have a problem with the handbook, but if they're doing that already, then I'm not sure, why do we need this?
Well, because this is focused on wear and carry permit holders especially, and the law about that is rather specialized. So what you're talking about is going to be two different informations. So the requirement in HB 824 was for changes in the existing law, but that didn't address the requirement of a whole body of law describes what it is now. So while it assumes you already know what the whole body of law is now, and you only advise of changes. The booklet that we're talking about here, the handbook, which I'm perfectly happy to have it electronically only, is going to be something that's a compilation of existing laws so people can educate themselves. So attached to my written testimony, you have the current curriculum that the Maryland State Police put together in response to 824. It's 70 pages long. About 40 of those pages are law. And it's not done very well. I also helped consult with that, and I actually corrected a bunch of errors. It makes sense, as Mr. Jocelyn says, to have the Office of Attorney General do this. The state police are advised by an Assistant Attorney General on daily matters. His name is Assistant Attorney General Bowen. And so they get legal advice as it is. So their consultation that this bill requires, as amended by the Senate, will also encompass that. So I'm not sure it matters who does the drafting, but as long as it's complete and full. There's a really crying need for just a compilation of this.
So I'm really surprised that you and Mr. Jocelyn, don't you have this on your website already?
I have a lot of
Yes.
it on my
Yeah.
website.
Yeah, okay. I was surprised. I just left Economic Matters, so I've got business on my mind. I can't believe that, there's not folks, there's a market, since there's obviously a market. Are there not folks who already provide handbooks or sell them?
There
or
really
anything?
isn't. No, not at all. So I have about 4,000 members in MSI. There's 182,000 wear and carry permit holders. There are many more than that who have handgun qualification license, who transport firearms to the range and the like in accordance with existing state law. Existing state law 4-203 really is very, very tricky. So there is no place where people can go to get full information about everything in Maryland law that affects the transport and wear and carry of a firearm. We do the best we can with our website, but it's not authoritative. People are not required to go there. People are not provided that information. We can only reach out to so many people. We don't have access to the email address for every wear and carry permit. That's considered confidential, and we don't have access to it.
One last question. And Mr. Chair, this is just my last question. Do you think, and I kind of already know the answer to this one, but I'm gonna ask anyway. Would it be, is it possible, or what do you think of the idea of having the folks who sell handguns actually providing this information?
The trouble is that they need a source for them to do it. They're not lawyers. So they're no more qualified than the layperson is to put this together.
Yeah, Madam Chair, if I may, from the dealer's point of view, they may incur liability if they're handing out a document that is no longer valid and they don't know that they haven't given, the most recent information. I publish on my website the compilation of Maryland's gun laws. It's 283 pages. And when I get a question, the first thing I ask them is, did you download the compilation? Yes, I did. I read it, but what does it mean? And therein is the problem.
I got you. Let's move on. I got it.
Thank you.
Thank you. Thank you very much for answering my questions.
Thank you, Mr. Chair. Two brief questions. So this year, physical notes are clearly an issue. We've been instructed to get every physical note under $100,000. This one's already over $100,000. The gentleman doing the training, anybody doing the training, do you think if we provided this exclusively in electronic format, that would be sufficient for what you do?
Yes,
absolutely.
Oh, that's two. Okay, 3 yeses.
Can I give my opinion on that?
Sure, absolutely.
I think that could be a short-term fix based on the funding. Maybe it's because I'm older.
Okay.
Yeah, but a lot of people I know would prefer to have a hard copy of it.
Me too.
Yeah.
A second question. So, Mr. Jocelyn, you mentioned there are problems getting the legal information from the state police, as the state police typically go through the Attorney General's office anyway, and that's why you suggested going through the Attorney General's office for the legal portions. Is that, can you extrapolate that a little bit, please?
Yes, the A2 section in House Bill 824 was done at my suggestion. What I suggested and what the bill drafter came up with were two different things. The intent was that the state police would create the training portion, the safety, all the procedures necessary for the hardware section, if you will. That the Attorney General would then author the law section, and to do it in a form that the common man can understand. Mark understands it, I don't. I'm an instructor, I struggle with it. I know my fellow instructors do. We think the subject matter expert should do it, and we should have the mental health people doing their package. They in fact did do that. They did their package and they provided it to the Maryland State Police. What happened, as best I understand it, was the Maryland State Police did everything they could to come up with a package. And the AG kind of looked over their shoulder and said, yeah, that satisfies the statute. Just because it satisfies the statute doesn't mean that it's a good working teaching document. And that's what we're striving for.
I've had conversations with the Office of the Attorney General, and we have an ongoing conversation about this.
Thank you, Mr. Chair. And I actually have nothing against the bill. I did want to kind of piggyback on what the Vice Chair and what Delegate Grammer were stating. One, I was looking at the Senate amendments, and it does mention in the Senate amendments still providing the handbook in a printed form. So that's something that would need to get reconciled, because back to what Delegate Grammer was saying, he's saying 100,000. I think actually the new word on the street is to get it to 0, to be honest with you. And so that's going to be, if we're able to kind of get this fiscal note to 0, I think maybe we can have a better conversation about that. The other piece of this, though, that I noticed, I don't know where I saw this at, maybe it was in some of the testimony. Oh, no, it was in the fiscal note about also providing the handbook in other languages. And I wanted to get you all's opinion about that as well, if that's something that you all would be amenable to. Because I'm sure we have gun holders here in the state of Maryland that speak other languages. And so that was my other question.
Oh, absolutely. Yes. And if you do it in electronic form only, that's a simple process.
I think according to the state police testimony, they currently would be required to publish it in English and Spanish, but there could eventually be other required in other languages as well.
Thank you, Mr. Chair, and thank you, Delegate, and thank you, panel again. Mine goes back to the printed version as well, and the Delegate touched on the segment of folks that this would be uncomfortable for. I know that the digital discussion is ongoing. My question is, Delegate, you referenced earlier in your testimony about hunting licenses and the hunting books and the fishing books. They're in a printed format, correct?
Yes.
And they go over different updates to rules, regulations, statutes in hunting every year, correct?
Yes, to include changes, annual changes.
To include updates and changes every year. So I guess my point is, and my question is, if that's available and it's available yearly as the changes come, I don't understand why this wouldn't be. So my question is, isn't that so? I guess, I guess my point is, they're doing it in these other aspects for hunting, fishing, they're doing it yearly, and this would be something similar.
In my mind, it would. I think the permit fee right now is $125.
Right.
I don't know how that's broken down, whether they make money on the processing or it just covers the expenses, but the cost estimates vary based on DLS's estimate of, I think, 123,000, and the state police say it could be 200, it could be 300,000. So, I mean, there's 175,000 plus permit holders. That's about $1 per permit holder. So I don't know what happens with $125, but there ought to be $1 in there somewhere to pay for the hard copy if it was required, my opinion.
Right. Thank you very much. That concludes the testimony on House Bill 1166. I think I got all the questions.
Thank
you all very much. Thank you. Now we have someone else who's at their first appearance in front of the Judiciary Committee. Delegate Wims, I don't know. All week committee has been saying how excited he's going to be to come here to the Judiciary Committee.
That's right. My first time here.
Let's see what he says in a few minutes. Vice Chair's job is to be welcoming.
Thank you.
Sunshine, rain.
All right.
Do you have everybody up there that you'd like with you?
Yes, and we might rotate one more after this.
The county executive is Bird.
He's representing.
Oh,
I'm representing the county executive. Thank you.
Okay, all right, that's fine. Okay, well, if you have another person, do you have another person who's supposed to testify?
One.
Come on up
Captain
and,
Jensen.
because I think it's only one more person to testify,
Yes.
right? Come on up and we'll make it work. Just bring a chair.
Two.
You can't take it with you out of the room, but you can move it up to the table. We'll figure it out. That's fine. We'll have you switch seats when the appropriate time comes. All right. House Bill 1111, here we go.
Okay, thank you, Mr. Chair and Vice Chair. For the record, my name is Greg Wims from District 39, and I'm here to present House Bill 1111, reckless endangerment with the use of a motor vehicle. And we also have an amendment to call it the Sergeant Patrick Kemp Act. It removes language that prohibits people from being charged with reckless endangerment through the use of a motor vehicle. Someone should not be exempt from endangering the public simply because they are in a car. In fact, they should be under more scrutiny or held even more responsible, as cars cause great bodily injury and even death when used in a reckless manner. The bill would allow drivers to be charged with reckless endangerment, holding reckless drivers with disregard to the public accountable. The legislation is inspired by the tragic accident that occurred on I-270 in Montgomery County a few months ago, where an officer was struck, and by the grace of God, the Shock Trauma Center saved his life, but he had to have both of his legs amputated. He's one of my witnesses today, and I call him a hero, Sergeant Patrick Kemp. Sergeant Kemp was struck by a repeat offender, dangerously driving, including incidents that the offender was driving in excess of 130 miles an hour. Currently, the driver could not be charged with reckless endangerment because he had used a motor vehicle. The law does not make sense and allows reckless individuals to engage in dangerous driving without the penalties that we are asking in this bill. I urge the committee to give a favorable report to protect our constituents and hold dangerous individuals accountable under the law. And I would like my first witness to be Sergeant Kemp.
Thank you, Delegate Wims. Chair Clippinger, Vice Chair Bartlett. My name is Sergeant Patrick Hepp of the Montgomery County Police Department. On October 18th, 2023, I was intentionally struck by a driver on northbound I-270 at Watkins Mill Road who was going well over 100 miles an hour. As a result of the crash, as Delegate Wim said, I lost my right leg on scene and my left leg was amputated after I was flown to shock trauma in Baltimore. With 2 minutes, I don't have the time to go into the full story. If you don't know it, I encourage you to Google my incident to get a full grasp of the seriousness of the events, not only leading up to the crash, but my long road to recovery since. What is critical to this proposed act is the individual I was trying to stop was a menace to the roadways of Montgomery County and Frederick counties. My history with the individual goes back many years, but to speak to 2023 alone, his actions, baiting the police, running red lights, skidding his tires, speeding through intersections, and most dangerously, driving at one point when I encountered him on May 26, 2023, 136 miles an hour on 270, a 55-mile-per-hour zone. Absent fleeing from the police, all these driving actions when brought to court currently would be punishable by a maximum fine of $530 and points on driver's license for reckless driving. Most traffic violations in our state are and should remain exactly that, traffic. However, when it came time for me to file charges against the individual in my situation, there were truly no appropriate criminal charges that applied outside of disorderly conduct. There's no doubt that turning off one's lights, going over 130 miles an hour, fleeing from the police, baiting the police, rises to the level of serious criminal conduct that poses serious danger to the life and safety of our community. This proposed law change closes the loophole that currently allows motor vehicles to be exempt from reckless endangerment. If we think of two other potential scenarios just off the top of my head, intersection takeovers that we see all too often where vehicles shut down roadways, skid their tires and spin in circles, not intending to hit somebody but potentially could, and then hit and run situations where someone is struck with that vehicle as a weapon, again, maybe not intentional. Those are serious things that right now have no serious penalties to them. I want to thank Delegate Wims for taking a stand against these extremely dangerous driving behaviors in light of my serious incident. I thank this committee for taking the time to allow me to share why these changes are so important, especially after my personal experiences, not only over my 10-year career, but especially in October 2023. I strongly encourage the Judicial Committee to favorably recommend this bill. Thank you.
Good afternoon, Chair Clippinger and Vice Chair Bartlett. I'm Dawn Ludke. I represent District 7 on the Montgomery County Council. In preparation for my testimony today in support of House Bill 1111, I looked back at the legislative history for the reckless endangerment statute, at least the portion which was electronically available. And what I was able to discern that I could not find anything back to at least 2000 that demonstrated why motor vehicles were exempted from the reckless endangerment statute in the first place. And so I thought about that, and given that the reckless endangerment statute is quite an old one and hadn't been modified in this substantive way since, that perhaps folks back then, policymakers, weren't contemplating some of the things that we've seen on our roadways happening now with great frequency were not happening then. During COVID, of course, as part of the work I did with the state with COVID enforcement with the state police and Department of Health, we would hear on the calls about people doing donuts on the Bay Bridge and donuts on the DC Beltway. But it hasn't stopped. In fact, things have just gotten worse since that time. So some of the things that could qualify as reckless endangerment if the exclusion related to motor vehicles are exempted as requested in Bill 1111 would be excessive speeding or reckless driving in a heavily trafficked pedestrian area, including in and around schools, shopping districts, Main Street thoroughfares. Road rage incidents, engaging in or initiating confrontations on the road that could lead to accidents or direct harm, including using the vehicle as a weapon. Vehicle ramming, deliberately crashing into other vehicles, buildings, or crowds as an act of assault or terrorism. Wrong way driving on the highway. That should be something I don't have to say, and yet it's something I do have to say. Throwing objects from vehicles, discharging items or projectiles from a moving vehicle, posing a hazard to other drivers, pedestrians, and property along the roadside. We've had a 13% increase in our traffic fatalities statewide between 2019 and 2023, and the numbers are just trending upward. Because of that, I ask you to give a favorable report to House Bill 1111 so that we can close this gap. Thank you.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the Judiciary Committee. For the record, my name is Earl Stoddard. I'm an Assistant Chief Administrative Officer in the Office of the County Executive in Montgomery County, testifying in favor of House Bill 1111. I have the pleasure of coordinating both the Vision Zero portfolios and the public safety portfolios on behalf of the County Executive. In Vision Zero, we talk a lot about deadly by design. But we also talk about the fact that users of the roadways need to follow the rules for Vision Zero to work. In Maryland, we largely rely on a series of fines and points to effectuate behavior change when people don't follow those rules. For many users, that works fine. However, in certain cases, there are such egregious wanton disregards for human life, safety, and the rules that we require a greater intervention. Obviously, that is the case that we saw with the individual that intentionally struck Sergeant Kep. But in that case, there should have been an opportunity for us to get that individual who had behaved that way in so many previous occasions off the roadway before he seriously injured Sergeant Kep. Under Maryland law, as Sergeant Kep alluded to, there are not those vehicles to act. It is a failure of our system of laws that we cannot prevent serious and fatal crashes when there are opportunities to do so because the law does not allow. What I would say lastly is I'm representing Montgomery County. Obviously, that means that both our executive and our county council unanimously agreed to support something that is a criminal law change, which I would imagine before this committee is a rare thing for Montgomery County to do collectively. And so I think this shows just how important we believe that this change is, and the fact that in order to make our roadways safe, we know we need to make a change that allows us to get people in front of a judge to make a difference in that person's life before they kill or injure someone seriously. So with that said, I ask that the county urges the committee to produce a favorable report for House Bill 1111. Thank you.
All right, I'll go next. Hello, everybody. My name is Captain Stacy Flynn, and I'm with Montgomery County Police. While I currently serve as the director of the Policy and Planning Division, as well as the legislative liaison, the bulk of my career was in traffic enforcement. And so this bill is something that I'm very passionate about, and I very much appreciate your time listening to us today. Many years ago, I had a situation where a woman was intentionally ramming another car in a busy Gaithersburg intersection. And the reason she was doing that is because in that other car was her cheating boyfriend. And while I could understand the sentiment, her actions, of course, were problematic. And when we finally got her stopped and we heard her entire story, we took her to jail. And it was a difficult situation because we could not charge her with reckless endangerment at that time because the law precluded vehicles from being involved in that particular crime. That's what this particular bill, House Bill 1111, is trying to change. It gives us a middle ground option so that we don't have to undercharge, which is simply traffic citations that sometimes don't make that much of a difference, especially when you have people that are routinely driving at high speeds, as Sergeant Kep referenced, or even overcharging when you have to turn around and charge somebody when the situation doesn't even apply with something very serious like felonious assault. So it gives kind of a middle ground. It's a punishable by up to 5 years in jail and or a $5,000 fine. So we'd really appreciate the opportunity to have that as a tool in our toolbox to combat some of this horrible traffic behaviors that we are seeing in Montgomery County. So again, thank you so much for your time. And we do urge a favorable report for House Bill 1111. Thank you.
I could ask the councilwoman to switch, please, with the gentleman to my far right. And those two to switch over there. We'll hear from you, sir. Go right ahead.
Thank you, sir. Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the Judiciary Committee. My name is Captain Warren Jensen. I'm with the Montgomery County Police Department, and I'm the current director of our Traffic Operations Division. I want to thank Delegate Wims for sponsoring this important traffic safety bill that seeks to enhance penalties for reckless driving behavior. This legislation aims to improve roadway safety in our state. Reckless, negligent, and aggressive driving continue to plague our communities. I think everyone's seeing that. This behavior puts countless lives at risk, drivers, passengers, and pedestrians alike. Currently, as they've spoken about, reckless endangerment cannot be charged criminally when a vehicle is involved. Officers are limited to citing for reckless driving, which is a prepayable traffic offense. This simply isn't enough to deter egregious, dangerous driving behavior or hold individuals accountable for putting other lives at risk. House Bill 1111 closes this gap. By removing the vehicle exclusion from reckless endangerment, the legislation allows us to criminally charge those who operate a motor vehicle in a way that is likely to cause serious injury or death. This stronger penalty sends a clear message. Reckless driving is not a minor violation. It's a crime with serious consequences. The Montgomery County Police Department strongly supports this bill. The bill strengthens law enforcement tools for us and would provide stronger penalties to reduce these dangerous driving behaviors. Our officers witnessed the devastating consequences of reckless driving firsthand, as you've heard from Sergeant Kep. We see the preventable accidents and injuries. This bill empowers us with stronger measures to prevent these tragedies. One quick story from my patrol days, I had a neighbor dispute. I had children who were playing basketball with one of those rollaway basketball hoops in the roadway. One of the neighbors took exception to this and did not like it. And every day when he came home, he swerved at the children. There was no intent to assault the children, so it made the case very difficult for us. I consulted with the district court commissioner and learned that there was a vehicle exception. That was the first time I had heard it. He had to be charged with a traffic citation, which was prepayable. I urge a favorable report and thank you for your time.
Thank you. Good afternoon, Chair Clippinger, members of the committee. My name is Kyle O'Grady. I appear on behalf of the Montgomery County State's Attorney's Office, where I serve as prosecutor in the Felony Trial Division, the Traffic Fatality Unit. Setting aside the similarities in their names, reckless endangerment, reckless driving are not the same offenses. First, the object of the disregard is very different. Reckless driving is the disregard of safety of persons or property. In criminal and traffic law, this is essentially the lowest standard that we have. Reckless endangerment requires substantial risk of death or serious physical injury. This is essentially the highest risk that we have in criminal law. Second, unlike reckless driving, reckless endangerment requires a showing of gross negligence. It's that a person is aware of and consciously disregards the risk. There's a subjective intent element there. As an example, let's say that two guys decide to show off their cars to each other by racing around county roads. They have fast cars, they're zipping around over 100 miles an hour. They're going through residential neighborhoods, they're blowing through red lights, they're overtaking and passing and swerving in and out of traffic that exists on the road. Now, if those drivers driving in an indisputably grossly negligent manner cause a crash that results in a fatality, they're going to be charged with gross negligent manslaughter by motor vehicle. That's a 10-year felon. If they take those same facts, same conduct, if they cause a crash in which someone is injured, those drivers are going to be charged with second-degree assault. It's an unintentional battery that is the result of grossly negligent conduct. That's a 10-year misdemeanor. Now take that same conduct. Numerous lives endangered, but there's no crash. This is where reckless endangerment would apply. Where we are now, it's a payable citation. In Perry v. State, the appellate court wrote that the purpose of the reckless endangerment statute is to deter crime before injury or death occurs. This is about deterrence and prevention. We can't keep waiting until these drivers kill or injure members of our community before we take action. On behalf of the Montgomery County State's Attorney's Office, we urge a favorable report on this bill.
Seeing that, I have some questions to begin, then we'll go to Delegate Conway. Mr. O'Grady, so in his testimony, Sergeant Kemp said that the driver intentionally drove at him. I don't know where that case stands right now. I don't know whether it's been adjudicated or not. Can you tell us where what he was ultimately charged with, the person who did that to Sergeant Kemp?
That driver's still pending trial now. He has been charged with attempted first-degree murder, attempted second-degree murder, and first-degree assault, in addition to other traffic offenses.
Yeah, the question that we were bandying about amongst ourselves over here was why wasn't, or was it an attempted murder, and why, would it be a first-degree or a second-degree assault at a minimum? Because if it was intentional, it was intentional, and
right,
you can prove it that way. So what you're going at here is not the intentional act, but something just a little bit less than that.
Everything leading up to that moment, essentially.
Everything leading up to it. All right, we'll go to Delegate Conway.
Thank you, Mr. Chairman. Thank you, delegate and panel, for coming in to testify. I believe I heard someone say something about under this bill, littering out of a car could be included. Is that correct?
Was talking about launching a projectile out of a car. So you're driving on a highway, you're having a road rage incident against someone, and you start throwing objects out of your vehicle.
As in a soda bottle or trash or something like that?
It's a hypothetical. Mercifully, I haven't experienced it, right? That's a good thing. But what we see on the roadways nowadays, we're seeing a lot more aggressive driver to driver type of intentional targeting. And there really isn't a mechanism for that now, right? And specifically with reckless endangerment, aside from the act on the day that led to the striking of Sergeant Kemp, all the prior incidents involving that particular driver that spanned multiple years even, there wasn't a thing. There was no reckless endangerment charge that could have been brought against the individual. All that could be written were traffic citations where he didn't have to appear.
So if two people are participating in a speed contest, they couldn't be charged with reckless endangerment. They would have to have a third party that would be nearby or something?
No, sir. There's just, you can't charge with reckless endangerment presently if the reckless endangerment emanates out of use of a motor vehicle.
Okay, thank you very much.
You're welcome.
Thank you, Mr. Chair. So thank you very much, Delegate Wims, for bringing this bill and sponsoring it for us. And I appreciate all of you Montgomery County police officers for being present and sharing with us. And of course, the councilwoman, but most importantly, you, Sergeant Kippy, for, for being here and to just present your story and what happened. Is there anything else that you would like to share with us?
I think the big point of emphasis, I tell my story because that's what gets me here. And that's unfortunately what's the impetus for change. But what is critical to this portion, as Councilwoman has testified and a bunch of us, it's the acts leading up to it. It's that I had interactions with this individual years in advance. And then in advance of the crash, just in 2023 alone, from May to October. So it's those actions that there was the only mechanism that I had at the time, and again, I won't go into too much of it because it's a pending case, but what I ultimately charged that's out there, it says public charges is disorderly conduct. And frankly, that's a stretch, right? Causing a disturbance to the public peace, sure. Going fast and revving your engine, yes. Using that statute, seriously endangering the lives and posing a serious risk of death and serious bodily injury to others. That's what drivers do when they go over 100 miles an hour, turn their lights off, swerve in and out of other vehicles. I can't tell you how many instances I've had since of people telling me, I think I've seen those guys driving, or I see people driving like this all the time. And again, not everyone needs to be charged with this criminally, but it closes that loophole for us right now that has traffic and then maybe those intent or actual collision cases. Like Mr. O'Grady said, that situation where two people racing, multiple people racing, going down the road, and there is no collision, or in the case of maybe a intersection takeover and someone doing donuts strikes someone with the tail end of their car and flings them up. That may fall into the second degree assault portion, but it's also reckless endangerment, which right now we can't charge because if a motor vehicle is involved, there is that exception there. So this just strikes that language. Thank you.
Thank you, Mr. Chair. Thank you for bringing this bill, Delegate, and really, really sorry for what happened to you. I was in church this weekend and one of my church members reminded me, one, that this bill was coming up, and two, that it was her son that was killed on a highway on 270 sometime last year. I think he was dubbed the Good Samaritan. He was helping someone and then he got, So I don't know the disposition of that particular case, but if we were to pass this law, would that help give this mother some solace with regard to what happened to her son who was killed on a highway?
Yes.
Thank you for the question. I would say yes. So what we see often is repeat driving behavior like this. And that's what Sergeant Kemp was talking about with his. We're not looking at the first time offender going 90 miles an hour and looking to take them to jail. Very often, and I don't know the specific case details, I had heard of it, but very often these are repeat driving offenders. And I think that's what we were talking about with probably that case and Sergeant Kemp's case. If we had some tools that we were able to intervene earlier and get this person in front of a judge and actually have some consequences rather than give them a citation and send them on their way, I think maybe that would have applied there. I can't speculate, but it definitely would have applied in Sergeant Kemp's case. Do you have anything else to say to that? I think it would. I think it's important because of the repeat behaviors. Thank you.
Thank you, Mr. Chair, and thank you all for being here today. And I'm sorry about this tragedy and as the reasoning why we're here today. I did have a question, and I don't know, Delegate Wims, if you had a chance to review the letter of information that was submitted by MDOT. And so if you haven't, I think someone can certainly get that over to you. But they did mention a few concerns raised, or I shouldn't say concerns, maybe points raised, that if this bill were to be enacted, that because of the way the bill is structured, they wouldn't be able to assess any additional fines, points, or take any other administrative actions against the convicted individual, quote, end quote. So I don't know if you guys have reviewed that, if you have any thoughts about that. And if not, maybe this is something to think about and maybe have a conversation with them regarding that.
Delegate Williams, I did see that letter, and we are working now, well, on the Senate side, but also trying to see if we can work things out where it would be, they would be acceptable to it in MDOT. I'll just put it that way.
And if I could just add, ma'am, in these types of situations, again, this is a tool and this particular offense would be a criminal offense. And typically speaking, when we have an incident, when it's applicable, the person is often charged both criminally as well as the traffic part of it. And then from there, it goes to the state's attorney's office where they typically work something out. So it's not that it wouldn't, that the ability to put fines or points on their license wouldn't exist. It would just have to be a collaboration. And then I also just wanted to add regarding throwing stuff out the window. It's more designed, sir, for those situations. If you've ever heard where like someone's tossed a double D battery at somebody, something where you can actually harm somebody when you're not littering. That's not what this is about. But if you take something, heavy and hefty and you're lobbing it at another car, but you're involving your vehicle in that process, that's more, I think, what Councilmember Lutke was referencing. Thank you.
All right. Delegate Tolles.
Follow up to that. So it would not it would be different than say someone, we've seen individuals that throw bricks or rocks off a bridge, thinking it's for fun and it's really harming someone. It would not be used in this situation because it's not with the use of a vehicle.
Reckless endangerment already would apply to that situation potentially, because it has nothing to do with the use of a motor vehicle. In that situation, it's the use of a brick. In what we are attempting to address right now is the circumstances of dangerous driving, where the dangerousness to the community is directly from the person sitting in the driver's seat of a car and the manner in which they operate that motor vehicle.
It just reminded me of a case I had in law school where they do that, the break or something. Just one. And again, thank you for being here, and may God continue to just heal you. Thank you.
Thank you, Mr. Chair, and to Mr. Kep, thank you. Thank you for your service, and thank you for what you've had to endure. I just want to ask a question. Does anybody know why there was this exception in the law in the first place?
I think that's what Councilwoman Lutke alluded to. She did her research and going through case law and looking back through the statute. And I believe as she testified to, there's nothing that she could find as to why it was. And it's just that loophole that does exist now. So it's that's what we're looking to close.
Thank you.
Okay. Seeing no further questions, we thank you very much for being here today. Thank you very much for your testimony.
Thank you, Mr. Chair and the committee.
That concludes the testimony on House Bill 1111. Now, someone who is a neighbor has a bill. It's not her first time in front of the committee. She once promised she would never come back, which I thought could not be possible, and I was right, for the record. Delegate Robin Lewis, House Bill 1267. And now that I've given her enough grief, she can begin to present her bill. And I see your panel as well. Please go ahead.
Thank you so much, Mr. Chair, and my district mate and friend. I'm very happy to be here before you, Delegate Robin Lewis, on behalf of House Bill 1267, Extreme Risk Protective Orders Review of Court Records. I'm here with my panel, and I do have a virtual panelist as well. Myself, Eileen Zeller, Professor Shannon Frateroli, and Jen Poliakonis online. So with your indulgence, I'll get started. I did say I would never come back here, but here I am. Okay. So thank you, Chair Clippinger, Vice Chair Bartlett, esteemed colleagues of the Judiciary Committee, Robin Lewis, on behalf of House Bill 1267. This is a bill that will allow researchers, academic researchers at academic institutions to have access to extreme risk protective order data. I'll use the acronym ERPO for short, not HARPO from the Three Stooges, but ERPO. Some of you were here in 2018 when the General Assembly passed legislation. We refer to it as the red flag law. Many states have passed such laws, but they're designed to prevent gun-related tragedies. The ERPO law, or red flag law, gives law enforcement, family members, healthcare providers, and other specific individuals the ability to petition a court to temporarily remove firearms from individuals who are at risk of using guns to hurt themselves or others. Our current red flag law allows court personnel, the respondent or counsel for the respondent, the Maryland Department of Health, local mental health authorities, and other law enforcement to access relevant court records. These records are already confidential. What the bill before you does, it just adds academic researchers to that list of entities that have access to the ERPO or red flag data. Without this data, researchers simply can't access the data, then they can't effectively evaluate the law, its implementation, its impact, whether it's being equitably and effectively enforced. And we really need our researchers to be able to do that, to answer those questions for us. The bill doesn't change the ERPO red flag law in any other way. It doesn't change who can petition the court. It doesn't give the public access to court records and court proceedings. It just adds researchers to the list. If you don't already know, researchers are really important to the work we do as policymakers. They conduct studies, they evaluate the impact of our laws, and they give us feedback. You timed the sponsor here? I object.
An objection has been made to the rules of the committee. All in favor of the chair's rules on this matter, say aye. Opposed, nay. Motion carried. Your objection has been overruled. I'm sorry.
Oh, see, that's why I didn't want to come back.
Take a couple seconds and wrap up.
I'll wind up. Thank you so much,
Thank you
Mr.
very
Chair.
much.
Thank you, colleagues. My panelists can tell you a lot more about the reason why we want researchers to have access. So I will close out by saying I urge a favorable report. Thank you. And if Ms. Zeller could go next.
Hi, thank you for having me today. Thank you for giving us this opportunity. My name is Eileen Zeller. I retired 6 years ago from a career in suicide prevention and public health. In retirement, I serve on the board of the Mental Health Association of Maryland, which also submitted testimony. I'm past chair of the Governor's Commission on Suicide Prevention, and I spent the last 10 years of my working life in the federal government's suicide prevention branch of the federal government's Substance Abuse and Mental Health Services Administration, where I was lead public health advisor. There's one thing I've learned over the years, is that there will never be enough resources to implement every strategy that can prevent suicide. We need to focus on the ones that research tells us are effective. You know from written testimony that research in other states suggests that ERPO laws are effective in preventing firearm suicide, but we don't yet know whether Maryland's law is effective. This bill will ultimately get us there. Firearms are the most common method of suicide nationally and in Maryland. Gun suicides are highest among men, people living in rural communities, people between the ages of 55 and 59, and those over 80. To prevent the most suicides, we need to focus on those groups. So here's an example of a study that is already giving us ideas of actions we can take. Last year, Dr. Federoli and colleagues published an article on ERPO petitions in 6 states, including Maryland, for people over 65. They found that 1 in 6 of those older adults had a cognitive impairment like dementia, and about a third were suicidal. Older adults have elevated rates of gun suicide, and dementia can increase their risk of firearm-related injury or death. What does it tell us? That we may want to educate families with at-risk relatives about the risk and availability of ERPOs. We can do that through healthcare providers, adult daycare centers, faith leaders, whatever makes the most sense in local jurisdictions. I ask for a favorable report and thank you for your time.
Good afternoon. My name is Shannon Frateroli, and I'm a professor at the Johns Hopkins Bloomberg School of Public Health, where I'm also a core faculty member with the Center for Gun Violence Solutions. I've published several papers on ERPO laws, worked with people who are implementing ERPO laws in Maryland, as well as in states around the country. And I hear almost daily from people who have questions about ERPOs, how they're being used, and their potential to impact gun violence and safety within our homes and communities. Just by way of reference, I live in Baltimore City, and I'm here today as a private citizen, not necessarily representing the views of my employer. So in 2018, in voting to move forward Maryland's ERPO bill, you all did your job as legislators. I thank you. Maryland's law enforcement community, including sheriffs, police, and courts, are doing their job in implementing ERPO. Every jurisdiction in Maryland is using this law, and Maryland is viewed as a model for ERPO implementation around the country. And I'm here today asking all of you to help the research community do our job. Our center is a resource for clinicians, for law enforcement, for community organizations around the state and in states throughout the country who are interested in learning about extreme risk protection orders and how they can be used to advance public safety. The information and assistance we provide are better informed by data about who is petitioning for ERPOs, the types of dangerous behaviors that prompt ERPOs, and how often courts are granting ERPO orders. Access to data is critical in answering these questions. I want to assure you that we take concerns about privacy seriously. We're governed by institutional review boards that assure that. And I urge a favorable review from the committee. Thank you.
Ms. Poliakonis.
Thank you so much for having me today. Chair, Vice Chair, members of the committee. My name is Jen Poliakonis, and I'm the Director of Policy and Programming for the Center for Gun Violence Solutions at Johns Hopkins University. I just want to follow up very quickly and finish some of Professor Shannon Frateroli's comments on privacy and institutional review boards. And I'm also happy to answer any questions, as is she. But for privacy questions, as we create this confidentiality exception, university research is subject to oversight by these institutional review boards, which is operated under federal regulations that govern research. IRBs focus on the protection of people who participate in the research, which would include all of the data in court records. As part of this, IRB is responsible for ensuring privacy, safety, and security of all research subjects. Any researcher who wants to seek access to these Maryland ERPO case files must first submit an application, show good cause to the IRB before they approve it. Anyone who's working on that research team needs to conduct complete training by the same federally regulated IRB and be approved by that same board before they are allowed to study or access any of this information. Once it's studied, this information is de-identified. There is no personal information that would ever be a part of the published reports. So I just wanted to make sure that we talked about that very quickly. The Johns Hopkins Center for Gun Violence Solutions requests a favorable report on this bill. As someone mentioned earlier about the low fiscal note, this is a small change to the law. It is a zero fiscal note, but it could have big impact to the research and public health community. So thank you.
Yes, Delegate. Is there anything else you would add if you had more time?
Yes or no?
Thank you, Delegate Simpson, for your generous question. Just to check the House rules, can more than one person answer a question on the panel? You know, HTO, we're different. We're nicer. Shots fired.
Makes it hard to love you sometimes.
So I think that's a great question. There are probably a couple of things that Professor Frattaroli might want to add, and I'd love to give her a chance to do that.
Yeah, I do understand there are concerns about privacy, and that was the main reason for including this confidentiality clause in the original bill. So I want to just emphasize the oversight that is present for academic institutions who would conduct this research before having any access to ERPO case files. I, as well as my colleagues and other institutions of higher education, would need to first get approval from a board, submit an application, and that oversight is again part of a larger regulatory framework that's governed by the federal government. So I just wanted to emphasize that there are strict protocols and systems in place to support any privacy concerns that might be at issue here. Mm-hmm.
Yes, Delegate Lewis, good to see you, and I can see that you and Delegate Kleppinger enjoy teasing each other. My question is this: did you have a chance to read the Judiciary Committee's the Maryland Judiciary's letter of information? Because they had a question about whether or not the medical records and things like that should be redacted. So I'm happy to email it to your office, but I suggest, of course it's up to you, but I suggest you reach out to Kelly O'Connor to see if you can answer her question.
Thank you so much for flagging that, Delegate Kaufman. I do have that letter. I'll be honest, in my view, it's a question well placed for deliberation by this committee. I don't have any strict objections, but I welcome conversation with this committee and the appropriate subcommittee to find an agreeable consensus way forward.
Thank you, Mr. Chair. Thank you, Delegate, and thank you, panel. I believe this question is best addressed to Ms. Poliakonis. Thank you. I think you already addressed some of this. I may have missed some of your testimony when you were going over it. And this has to do with the different entities that have access to these records now and some of the processes in place for them to obtain them. And I'm trying to determine if this bill would kind of mirror. And what I mean by that is I reached out to one of my local state's attorneys to see how they obtain these records now for when they have to obtain one of these orders and the documentation for related criminal cases. And it was explained to me that they file a motion with the clerk's office. They receive a order signed by a judge to unseal this record. And once they have the records, they send both notice out to all parties that these records have been provided. Did your testimony go over the fact that this would be similar for types of records that you're trying to obtain? Did you say that earlier?
I'm not sure exactly about that process. Professor Shannon Frattaroli might have a better idea about this as she's worked with the Attorney General's office on temporary access through their crime trace study that they acquired.
That's really my question, is how easily accessible are these and what process is in place for you to have this access, similar to what the state's attorneys have to do now?
Yes, so as was mentioned, when we gained temporary access, we worked through the Attorney General's office. And that process seemed to, it was managed by their office. I'm not sure what kind of behind the scenes processes happened in order to facilitate that. But the records were made available to us through that office.
If I could, just one other question, quick follow-up, is now this would be case specific, so you are looking at a specific jurisdiction, a certain, like, I guess, how targeted, are you going statewide? What is your overall goal?
Yeah, the bill is for any academic institution to have access to any sort of combination of statewide, local, ERPO data. So it would really be dependent on the researcher, the questions they're asking, what data request that would be. Yeah.
Seeing no further questions and no further testifiers, that's fine. That completes the testimony on House Bill 1267. Thank you very much.
Thank you. Thank you.
All right. Delegate Phillips now. House Bill 1079. And just making
Thank you, Mr.
sure
Chair.
you want to bring up your first panel. We
Yep,
need
first
Judge
panel.
Grimm, please, to be added remotely. Michael
Mr.
Winkleman.
Ms. Clark, Ms. Joyce, Mr. Herrick,
Got it.
Aaron, and
The judge who will be on virtually.
may change up our order just a little bit, Mr. Chair.
I think we've got the right names up there at least.
I got the
I'm not
right
worried
names.
About the order. You can go up
Yes.
in whichever order you want.
Thank you.
All right, go ahead.
Delegate, sorry, we need to have Judge Grimm on your panel.
He is on the panel. He's on the panel. All right. Good afternoon, colleagues. Mr. Chair, Vice Chair Bartlett, and the members of the judiciary. Thank you. I'm here asking for, my name is N. Scott Phillips, member of the Judiciary Committee representing the 10th Legislative District. I'm here asking for a favorable report on House Bill 1079, a bill that would change the rules on jury examination, the process known as voir dire. The purpose of voir dire is to impanel a fair and impartial jury. I know many of my colleagues on judiciary are not attorneys. And even for those of us who are, many of us are not trial attorneys. So I have a panel that will first give you a primer on Maryland's limited voir dire system. Maryland, in many respects, is an outlier in the process of selecting jurors. The subject matter experts will then share why we need to change our current process and why these changes are likely to provide for a fairer and more impartial jury. They will also refute the concerns raised by the Maryland State's Attorneys Association, and they will address the concerns raised by the judiciary. What we are proposing is not new or radical. It is a way that most states operate today. It is the way that the federal trials operate today, and you will hear from a retired federal judge who will provide his perspective. The witnesses in favor of this bill represent some 13 trial advocacy organizations, from the Office of the Public Defender to the Office of the Baltimore City State's Attorney, from the Hispanic Bar to the Alliance for Black Women Attorneys, from Charles County to Howard County. Why are lawyers on all sides of the bar supportive of these changes? Because they understand that with expanded voir dire, there is a greater opportunity to strike jurors who may have an implicit bias and the inability to be impartial. Isn't that what you would want if you were on trial? I will quote my friend, State's Attorney Ivan Bates, who has been on both sides of the trial table, prosecutor and defense attorney. His words, "I believe this bill represents a crucial step towards ensuring a more just and impartial legal system for all community members." House Bill 1079 will broaden that scope by permitting questions which tend to provide information relevant to considerations of fairness and impartiality. Obtaining more information from jurors will better inform the evaluation into whether potential jurors are able to be fair and impartial, thereby promoting transparency, fairness, and efficiency to the jury selection process. It is for these reasons that I ask for a favorable report on House Bill 1079. We'll start with Mr. Winkleman.
Thank you, Delegate. Mr. Chairman, members of the committee, my name is Mike Winkleman. I'm a practicing attorney in Prince George's County. I would like to give members of the jury a very quick understanding of how jury selection works in the state of Maryland. Generally, before trial begins, the judge will ask for a panel, and the panel will be brought in of between 30 to 100 people. The judge will place them under oath, and then the judge will ask them a series of questions intended to limit or exclude people that would be prohibited for cause. For example, do you know the facts that bring us here today? Do you know the parties? Do you know the attorneys? And if one of the members of the panel says yes, then they're stricken for cause. The judge then proceeds to the next set of questions, more particularly suited to the case. For example, if the case involves a robbery, have you ever been the victim of a robbery? Has your family ever been the victim of the robbery? Do you have any particular knowledge that would be relevant to the case? And if an individual answers yes to any of those, if a prospective juror answers yes, judge will bring them to the bench. Judge will ask some questions, and then the judge will ask this exceptionally important question, which is this: would that experience affect your ability to render a fair and impartial verdict in this case based solely on the evidence in this case? And if someone says, I couldn't be fair and impartial, they're stricken for cause. If they say, even knowing that I could be fair and impartial, they're returned to the panel. After that process is done, then the attorneys and their parties are allowed to use what are called peremptory challenges. Those are left to the discretion of the individual attorneys and their clients, and there are certain constitutional limitations on that. Those are between 4 and 8 per case. After that is done, whoever is left over is then seated as the panel. So it's the 6 to 12 if it's civil or criminal. Those 6 to 12 are who becomes the jury. So in Maryland, we don't select the jury. We select who's not going to be on the jury, and the remainder become the jury in your case.
Ms. Clark?
Good afternoon, members of the committee. My name is Patrice Meredith Clark. Oh. Good afternoon, members of the committee. My name is Patrice Meredith Clark. In 1905, Maryland's High Court consisted of 7 white men. That court decided that Maryland would have what's called limited voir dire. Maryland was very different in 1905. Women couldn't vote. Schools were segregated. The NAACP did not exist. What we know about discriminatory practices and bias, implicit bias, has changed enormously since 1905. But Maryland's practice of limited voir dire has not. Fast forward to 1993. In Davis versus State, Maryland's High Court declined to revisit this issue, saying the future of preemptory challenges is a legislative question. If the General Assembly wishes to expand or contract those statutory rights or the manner in which they are exercised, it may do so. Fast forward another 20 years, 2014. In Pearson versus State, the High Court again declined to revisit this issue, but this time it wrote a footnote and it asked the Rules Committee to investigate and to make recommendations about whether or not to expand voir dire. The Rules Committee did so, and the very first recommendation it made in 2014 was to expand voir dire to bring Maryland in line with the federal courts and the vast majority of other state courts. That was 10 years ago. House Bill 1079 simply adopts the 2014 recommendation. It does not tell trial judges how to conduct voir dire. In fact, it relies on trial judges to do what they already do: analyze each case that comes before them, review the requested voir dire, and exercise their discretion on whether to permit a question or not. Right now, the questions that are permitted must be designed to reveal explicit bias. This bill gives the opportunity to get to implicit bias, meaning biases that jurors might not even be aware of. We request a favorable report. Thank you.
I have to wait for the time. Good afternoon, everyone. My name is Laura Zoyce, and I've been a civil trial attorney for 29 years. I've been on the front lines of picking civil juries my entire career. I've sat on both sides of the courtroom. I've represented defendants and I've represented plaintiffs. Seating a fair jury is the single most important part of a trial. A fair jury will give you a fair verdict. Let's talk about bias for a minute. There's explicit bias and there's implicit bias. What is explicit bias? Explicit bias is when a potential juror in an open courtroom says, I have a problem with this entire group of people. That doesn't usually happen. Let me tell you a story. It's a beautiful summer day here in Annapolis. There's a 2009 silver Camry going around Church Circle. The driver is a nursing student and the passenger is a kindergarten teacher. How many people just envisioned two women? That is implicit bias. Implicit bias is basically our unconscious mind filling in facts for us. What does any of this have to do with this bill? Jurors don't typically admit to having an explicit bias, and they're not even aware that they have an implicit bias. So we need to be able to get more information from them to be able to determine if there's explicit bias or implicit bias. The scariest of all the jurors are the ones we hear nothing from. They don't answer a single question. We know nothing about them. But what we do know is what their race is and what their gender is. And the two things that we're not allowed to use preemptory strikes for are race and gender. So 1079 gives the court and the attorneys the tools that we need to get a fair jury for a fair verdict.
Right now, in courtrooms throughout the state, jurors are being picked, and they're being picked by lawyers. And as Laura said, those lawyers know very little about the juror. Any juror that doesn't speak, how hard is it for a lawyer to avoid using race or gender when they don't know anything else? What does this bill do? It's very simple. It widens the scope of voir dire to add peremptory challenges, just like it is in federal court. What it doesn't do is prevent a judge from controlling the process. It's not going to take any longer because it's up to the judge. And any lawyer that's picked a jury knows that the judge is going to give you strict time limits as to how much time there is. And here's the thing. How does it help? Well, what it does is it allows us to submit questions that right now we have to submit a question and an argument happens. Is it for cause? Isn't it for cause? We can now say if this law has changed, look, Judge, you may not think this is for cause. I think it goes to implicit bias, but you may not agree. I'm asking it for a peremptory challenge reason. And how does that work in the real world? Well, let's say we haven't heard from 3 jurors, right? And I say to those jurors, or I say to the judge, can you bring them up one at a time? This is the question I want to ask. I just want to ask them, you heard a lot about this case. Is there anything that makes you feel like this isn't the right case for you to sit on? Or maybe you'd be more comfortable sitting on another case? And if they say yes, then they probably have some kind of implicit bias that they're not aware of. Why is that important? Because they would never ask that question. If I tried to ask that question with the judge now, the judge would say, the only question is, can they be fair? Well, it's a big ask for somebody to look at somebody in a robe who's a higher standing than them in the legal community and say, I can't be fair because I'm a racist or I'm a sexist or I'm a misogynist or whatever it is. It's much easier from saying. Now, if that juror said to me in that case, I don't think this is the right case for me, I wouldn't get a challenge for cause stricken, but I could use a peremptory challenge. That's what this bill does. It gets us a chance just to ask the question. Now, if we ask a question and the judge says, Mr. Herrick, I don't think so, I'm not going to ask that. Well, the judge has the discretion to do that. I would urge favorable.
I'd like to go to Judge Grimm.
Good afternoon. Thank you so much for the opportunity to speak to you today. My name is Paul Grimm. For 26 years, I served on the United States District Court for the District of Maryland, first as a magistrate judge, then as a district judge. So I have had the privilege of having almost 26 years of presiding over jury trials. Key to remember is, number one, jury trials are the most sacred, one of our most sacred fundamental rights enshrined in the Constitution in civil and criminal cases. Number two, jury trials, the goal is to have a fair and impartial jury. Number three, Maryland already allows the exercise of preemptory challenges, but does not let the lawyers and the judge inquire to have a basis that's a non-prohibited basis for making those challenges. The State's Attorneys Association, and there are some people who've expressed reservations. You have had at least a 26-year experiment in your own state involving the federal courts, where both of these types of challenges in voir dire to establish preemptory challenges and challenges for cause controlled by the judge. Any judge who tries, any lawyer that doesn't think the judge controls voir dire has never tried to take voir dire in federal court. The judge is going to make sure that it doesn't go too far. And I can tell you that there are times when a juror has answered a question in a way that I would not have stricken for cause, answered a question on that was relevant to implicit bias in a way that I thought it was justified for the lawyers to strike them preemptorily because they would hesitate. Well, Judge, I think I could be fair and impartial. I would try. A lot of judges would let that juror stay. And I think that the lawyers should have an opportunity to exercise preemptories to knock them out. The numbers are limited. The law already allows it. It should be allowed to be done effectively.
Good afternoon, distinguished members of the House of Delegates, members of the Judiciary Committee, Chairman Clippinger, and Vice Chair Bartlett. My name is Petra Aaron, and I urge a favorable report on HB 1079. I am a proud trial attorney, a proud plaintiff's attorney currently, and a proud former assistant state's attorney. As a trial attorney, one of my most important tasks is to ensure that a fair, unbiased jury was impaneled to decide my victim or my client's case. As an ASA, I was allowed to provide questions to the judge prior to the jury selection process. That judge would wean through those questions, and then both sides would offer those questions, and then he or she would offer jury instructions. And then I was also allowed to approach. I was able to approach with opposing counsel, and we were able to ask follow-up questions to the judge's questions. So you can imagine my shock and horror when I began to try my very first civil jury trial. My co-counsel and I didn't open our mouths once. We weren't asked to approach once. We picked a jury in minutes. I was used to picking a jury in the morning, having opening statements in the afternoon. We picked a jury in minutes. That experience should not have been that disparate. It is important that unbiased juries exist not only for criminal cases, but also for civil cases. There should be unbiased juries in every courtroom in Maryland in civil and criminal cases. And that is why I urge a favorable report in HB 1079.
All right, questions for the panel. Delegate Munoz, see many more.
Thank you, Mr. Chair. Thank you, Delegate, for bringing this bill. I think this is a really important piece of legislation. As you know, the criminal case against the gentleman who robbed my husband, the first case was actually hung jury because of a biased member of the jury. And so he had to go through the whole experience again. And it was really difficult for our family. And so I was hoping perhaps the trial lawyers on your panel could respond to the concern that this legislation will lengthen the time it takes to do a jury selection. Can you kind of respond to that preemptively for me?
Thank you, Delegate, for your question. The truth is, we don't have to speculate because, as Judge Grimm said, it's always been this way in federal court. And we know that federal court jurors picking a jury in federal court takes no more time than it does in state court. So when someone says, sometimes people are worried about what they don't know. And the State's Attorneys Association practices in state court. They don't practice in federal court. That's why it was so important for Judge Grimm to give you his take and his understanding and his experience. And remember, what's important is what the bill does not do. It does not take away. You are not prescribing to judges, here's how you do it. All this bill says is we're going to widen the scope so you can get to some implicit bias. If I submit 100 questions, the judge is going to laugh me out of the courtroom. I might get one question. I might get 2 questions extra, something that's case specific to one of our clients that the judge really doesn't understand because they don't know the case because it got assigned to him the day before. That says, look, this is really important. It's really important, Judge. And I know you don't think it goes to cause, but it does go to peremptory challenges. Can I just get this one question? That's one extra question. But the most important thing, Delegate, is if in fact an extra 5 questions strike 2 jurors for cause, isn't that what they're supposed to do? Could we really say expediency of saving 5 minutes is better than have a jury with biased people to have to go through what your family went through? Of course not. That's why this is so important.
Yes, Mr. Chair, thank you. I have 2 questions. One, my first question is directed to the young lady on the end. You were talking about the Rules Committee and how there was a task force to study this in 2014. It was a recommendation from the Rules Committee. Do we know why the judiciary decided not to adopt the recommendation from the Rules Committee at that time?
Thank you for the question, Delegate Williams. We do not know what the inner workings of the court's decision-making. All we have is the report from the Rules Committee, and it is a 15-page comprehensive report that makes comprehensive recommendations and takes a look at the way that all of the other states do it, the way that federal courts do it, and came up with the recommendation to expand voir dire. We're not clear why the Court of Appeals hasn't implemented it. All I can tell you is that was 10 years ago.
Right. And then I have a follow-up question, if that's okay. Also too, and anyone can answer this, how many other states have this type of voir dire process, similar to what we have here in Maryland that is as restrictive or as limited to our process?
It's a very easy answer. I've written numerous articles about that. The answer to your question is 0. No one has as restrictive voir dire process as we have. None.
Thank you, Mr. Chair. I'm trying to figure out whether you've kind of answered my question. But let me ask you this. My apologies if you said it, but I just didn't get it. So a you might be allowed a preemptive challenge, but are these the same questions that any other a lawyer might answer? In other words, is there a list of questions that really get to implicit or explicit bias, or are you able to design your own questions? That's one question.
Okay. The first question is, lawyers can submit whatever questions they want, and then the judge decides what questions to ask. But because the law right now says that the only questions that have to be asked go to cause challenges, if a lot of the time we spend in chambers wasting time arguing, Judge, this does go to cause, and the judge says, no, it doesn't. That's a waste of time. We don't have to argue that now. We can say, look, I don't care if you call it cause, peremptory, who cares? It's why it's important in my case. I know you don't think it's going to give an answer that strikes for cause, but I needed to make a peremptory strike. It may be that they do give an answer that strikes for cause. And then the judge says, and I've had that once or twice where I've convinced the judge, just give me one question, Judge. And then it gets a cause challenge. And after the trial, the judge says, you were right. I probably should ask that question, So that's what it does. That's the answer to your first question. Thank you for the
Judge Grimm, did you want to say something?
Thank you very much. Delegate, to answer your question, I can tell you that there have been instances in my experience picking juries in civil and criminal cases where I control the initial voir dire. What I would do is I would meet with the parties. I would get their proposed questions. I would submit my version of that. I would sometimes use their questions, sometimes others. I would conduct the voir dire examination. I would ask all the questions. And then when I finish with a particular witness, I would ask counsel, do you wish to inquire? And I would let each side briefly inquire. If I thought the question was inappropriate, I would say, counsel, we're not going to ask this juror to do that. But I can tell you, Delegate Taylor, that there were instances, and not infrequently, when the answers to my question would not have led me to strike them for cause, but the answer to the follow-up from the attorney raised a ground that I did grant a strike for cause. And when you have the preemptory challenges, it's frequently because the witness is being honest, but is really struggling. I would do it, Judge. If you tell me to be fair, I'll be fair, but I think I can be fair. And when you get that hesitation, if a lawyer says, I'm not willing to take the chance on my client's case for a witness, a juror who seems to be struggling, it is a fair basis to do so. I do not think that there's any serious and certainly no empirical evidence to support that this bill, if it was enacted and reported favorably, would significantly lengthen the time for conducting voir dire. It would not weaken the authority that the trial judge has. And the Maryland trial judges are phenomenal. They are not shrinking violets. They are not going to allow the process to be dragged on. They know exactly when to draw the line. There's nothing in the experience that we've had in federal court with this that suggests that it would cause any of the problems that have been speculated by those people who have objected to it.
Thank you. The second question had to do with the length of time that, I've never been on that side of the jury selection. I've been through the part where you call to see if your numbers pick, your groups pick, and you go down and first thing in the morning and you wait for 2 hours, and then, you go in and there's a group and you may or may not get selected for the group. And then, if you are selected of this group of 100 or so, then you go into another room. I've never gotten to that part, but my husband did last week. And after 6 hours, he was sent home. But what you're saying is, this has nothing to do with that length of time that they're spending to get there. And even if you make it to that last 100 or so that are being really considered, for this jury selection doesn't really add to their time, or if it does, it's negligible.
This changes nothing about
Thank you.
time. It really doesn't. What it allows for is maybe a lawyer to get one or two more questions asked.
Perfect.
That's
Thank
really
you.
what it does for. Thank you, Delegate. Appreciate the question.
Thank you, Mr. Chair. I almost feel like this is a follow-up. I think she was in my head a little bit, but thank the panel for coming out. Two simple questions, and I'm just looking for clarification myself. What is the qualifications for someone sitting on a jury? And as well, what is a jury of your peers? What does that mean?
Mike, do you want to handle the qualifications? Yeah.
I'll try if I may, Delegate. The qualifications, we would spend considerable time trying to explain to those. Generally, you have to be a citizen of the jurisdiction in which you're sitting. I'm in Prince George's County. You'd have to be a citizen of Prince George's County. You would not have a pending case in that county and circuit, or I think it's just circuit court. You have to be over 18 years of age. There are a few other qualifications, but generally those are what they are. And then the broader question, Delegate, and I'm going to be very candid with you, of what is a jury of your peers? We could spend hours and hours discussing that and probably not achieve an adequate answer.
So there's nothing in definition?
It is not.
Okay, that's
Yeah.
what I was asking.
It is
All
not,
right.
Delegate.
Thank you.
The one thing everybody can agree at, but is it should be a fair jury. And that's what this bill tries to do, a fairer jury than we have now. And that is in the Constitution.
Yeah, thank you. And being the non-lawyer, it might take some time. Just walk me through, because I have a bill in, as you're aware, Delegate Phillips, that allows for individuals who were formerly incarcerated to serve on juries. And my concern, and help me, I could be misconstruing this, is that one of the questions could be, have you been incarcerated previously? And does this create a bias to our jury pool? And you, first we'll stop there and I'll let you answer.
Well, I would defer to Judge Grimm because he's a judge on this, but this is what I would say very briefly. Okay. It may very well be that if that law passes, and I know the law, I know you've heard testimony for it, but if the law specifically says it can't be asked, then it can't be asked. I'm not positive, but the reality is it's still up to the judge's discretion. If the judges think that's an intrusive question based on the law, if it does in fact change, the key is that it's up to the judge.
May I briefly respond? I'm familiar with that legislation. I think I testified on it last year when Senator Carter introduced it. And it's great legislation. I think that it is sort of a brother, a sister to this legislation, in that it ensures fair juries. Because right now, one of the questions that Delegate Simmons just asked, one of the things that Mr. Winkleman didn't mention, was that certain convictions preclude people from sitting on juries. Hopefully, if that bill passes, then that won't be the case. And your question is, can people then ask, has anybody been convicted? I think the answer is, in certain circumstances, yes. But that is potentially a good thing, because maybe that person gets to sit on the jury because they have a life experience that helps them make a decision. Maybe they don't sit on the jury because they say, you know what, I really cannot be fair and impartial. Maybe it's a police brutality case and they say, I can't be fair and impartial towards a police officer or against a police officer. The point is that this gets to a question that gets to bias that we might not be able to ask. And hopefully both of these bills create a more fair and impartial jury. Thank you very much for the question, Delegate.
I think, Judge, did you want to weigh in?
The only thing I would say is that I agree with, first of all, it's laudable to be able to allow individuals who have a previous conviction to be able to serve on jurors under circumstances when they had not been able to before. I can tell you that I have had cases where it's very standard to ask, have you ever been charged with a crime, investigated for a crime, and then the person will come up and answer the question. We do those individual questions up at the bench so that the rest of the jury pool doesn't hear it, so we don't have to embarrass anyone. The lawyers are up there. And for someone to say, yes, I was prosecuted and charged with this offense. What was the outcome? I was found guilty. Did you serve a sentence? Yes. Did you think that was a fair process? And said, yeah, I was guilty. And that was 20 years ago. And I have never done anything like that since. And they've not been excluded for cause. So it is a qualification that's a relevant question, but it also allows someone to explain how their own views about the system are such that they believe that they had a fair shake and that they moved on and they could be fair and impartial. So I don't think it will necessarily cause an elimination for individuals under those circumstances. Might it cause some of the lawyers to not want to take a chance and to exercise their preemptory strikes? Yes, but they could exercise preemptory strikes now anyway. And it is a normal question to be able to ask, have you ever been arrested? Have you ever been convicted? And have them answer that question even now. That's a normal question to ask.
Thank you. So what you're saying is that both of these bills would actually help with our jury pool.
There you go.
Thank you, sir. Thank you.
Any further questions? Seeing none, thank you all very much. We'll hear from the second panel now. Christine Dufour, Vanessa Clark-Brooks, Matt Pavola. I don't know if Mr. Winkleman was on that first panel or not.
And Vanessa Brooks is my chief of staff, just put in my testimony.
Okay. Jeremy Witter is virtual. I have room for one more. I'm going to go with Stephen Nolan. All right, we'll start from my right here. Mr. Floor, please. Would you grab the microphone now?
Certainly.
All right, go ahead.
Thank you. My name is Chris Floor. I've been doing criminal defense work for over 3 decades, and I'm here also to represent the Maryland Criminal Defense Attorneys Association, who is urging a favorable report on this bill. The law recognizes that my client has a right to be there when the jury is selected, that the client has a right to accompany me up to the bench when questions are being asked of individual jurors, and it's by the judge. I want to make sure that for the non-lawyers, it's not the lawyers asking this, it's the judge controlling those questions and asking those questions of prospective jurors. But when all is said and done, for those of us that do this work and try cases, when I turn to my client and I say, 10 people haven't said anything, they haven't raised their hand, they haven't responded to any questions in the by the judge, what do? Help me select this juror. Which person should you take? And as was said in the previous panel, we've got gender, we've got race. That's not right. This bill is an effort to make the jury selection more fair. And the movement from Jersey and other places, I was on the MSBA jury jury reform commission, because I volunteered, because I feel it's important. I've practiced in 2 different states, and I know that there's different ways to do this. And even though I didn't want to throw my wife under the bus, I'm going to do that right now. God help me. So Mr. Clippinger's office was prosecuting a case that my wife was summoned to jury duty on. And we have been married as long as I've been practicing, 33 years. And when she came back after she was not selected for this gang case, I said, what did you answer to the question, do you ever talk about your cases with your husband? Because everybody, the judge, the prosecutor, Bill Davis, God rest his soul, who was defending the case, all knew me and knew her with my name. And I said, I don't. And I said, why? And she said, because I felt it was the wrong answer to give. I felt like I was doing something wrong. As Judge Grimm said, we're asking you to be effective in exercising what we already have a right to do. Right now, we're whistling in the dark and guessing. Thank you.
Thank you. Next.
Good afternoon, Mr. Chairman, Madam Vice Chairwoman, and members of the committee. My name is Crystalise Vergara, and I am a trial attorney with the Law Office of Jessica Moise. However, I'm here today on behalf of Maryland Hispanic Bar Association, where I serve on the executive board as treasurer. Maryland Hispanic Bar Association is a nonprofit organization whose mission includes serving the public interest by preserving the highest standards of integrity, honor, and professionalism among the legal community since its inception in 1993. Our members are comprised of legal professionals from diverse backgrounds who are focused on promoting reform in the law and judicial procedure in order to achieve these objectives. As such, we support House Bill 1079 as it is a crucial step towards combating bias and the appearance of bias in our courtrooms. Our members are intimately familiar with how implicit bias can affect a right to a fair jury. This will ensure equal representation and foster diversity within our courtrooms by removing potential jurors who are unable to impartially exercise their duty. We believe it will help ensure the Maryland litigants are afforded fair and impartial juries and thereby improve access to justice for all Marylanders. For that reason, and for the reasons you will hear and have heard today, the Maryland Hispanic Bar Association requests this body vote in favor of House Bill 1079. Thank you for your time.
Hi, my name is Matt Pavola, and this committee at 4 p.m. the Judiciary Committee will be happy to learn. I'm just here to say me too, but I'm going to say 4 me toos if I may. I'll keep it under 30 seconds. First of all, I've been a trial lawyer for 40 years, and I'm here today in my capacity for the Maryland Christian Legal Society. I'm currently on leadership and have been in that bar association for many, many years. I'm also here to say the same for the Public Justice Center, weighs in favor of 1079. Howard County Bar Association weighs in favor of 1079, and the Office of the Public Defender. So you can see the support from bar associations far and wide. Everyone that does trial work, just about everyone, is in favor of this. Thank you so much.
Good afternoon. My name is Nyasha West, and I am a trial attorney deeply committed to the pursuit of justice. Today, I sit before you as a representative of the Alliance of Black Women Attorneys, a collective united in our dedication to fairness and equality within the legal system. House Bill 1079 addresses a critical need for expanded voir dire in jury trials, a reform crucial in combating bias during jury selection. Bias, whether conscious or unconscious, can influence trial outcome, compromising the very foundation of our justice system. Time and time again, trial attorneys witness the impact of biased juries on our clients' lives. The Alliance of Black Women Attorneys stands firmly behind this bill, recognizing the profound impacts it will have in fostering impartiality, diversity, and ultimately a fair trial for all. Our broad-based support underscores the urgency of this reform. I'm also pleased to share that the J. Franklin Bourne Bar Association also endorses this bill, understanding its significance in promoting a more just legal system. Furthermore, I also have a letter of support from the Asian Pacific American Bar Association of Maryland, echoing our sentiments and providing valuable insights. In unity, we can propel Maryland toward a legal system that truly reflects the values of fairness, impartiality, and equal justice under the law. And I urge you to support House Bill 1079 and stand alongside us in this crucial endeavor. Thank you.
Good afternoon, Madam Vice Chair. My name is Steve Nolan, and I've been a trial lawyer for over 40 years. I'm a former president of the Baltimore County Bar Association, and I'm pleased to report that earlier this week, the Baltimore County Bar Association joined the Charles and Howard County Bar Association in supporting this important legislation. I'm also a former member of the Maryland State Bar Association Special Committee on Jury Voir Dire. 13 years ago, in 2011, the Maryland State Bar Association convened a special committee of judges and lawyers, quote, to develop and recommend for acceptance model voir dire questions to benefit the bench, bar, and parties to court proceedings. I had the privilege of serving as co-chair of the Tort Law Subcommittee of that special committee. 3 years later, as Ms. Patrice Clark described earlier, the Pearson decision came out, and the Maryland Rules Committee, or the Rules Committee of the Maryland Supreme Court, recommended that there be voir dire to include relevant inquiries designed to facilitate or guide the intelligent exercise of peremptory challenges in both civil and criminal cases. Just last month, the Rules Committee came out again with a report that talked about the problem of actual and implicit bias. For every week that the existing system is not corrected, the rights of plaintiffs and defendants to a trial by an impartial jury are not protected. Madam Chair and members of the committee, I respectfully request that you and all members of your committee vote in favor of House Bill 1079.
Thank you very much. And perfect timing. Mr. Witter?
Yes.
Yes, you can begin.
Thank you. My name is Jeremy Witter. I am a solo criminal defense attorney in Charles County, Maryland. I'm also the president of the Charles County Bar Association, and I am speaking on behalf of that organization that urges a favorable report on this bill. I was an assistant state's attorney here in Charles County for about 9 years, and I've been on the other side as I said, a private criminal defense attorney for the last 5. As I said, we certainly support this bill. The more information we can have as trial lawyers about jurors, actual information about that specific juror, the better we can do our job, the better we can pick fair juries. Oftentimes on these questionnaires, you just have very broad-based questions. You're not delving into individual people. And so all that we're really left to go on as attorneys in selecting, or rather striking jurors, is folk wisdom, your gut, or impermissible characteristics like race or gender, which A, is illegal to strike on those bases, and B, it's not even how you get to a good jury in the first place, because people are not monolithic. And if you just go off of those stereotypes, you're not, like I said, it's illegal, but you're not even doing a good job as an attorney. So like I said, this bill would eliminate a lot of that guesswork that we have to do as trial lawyers in selecting those jurors. The other thing I want to address is there was a concern by the MSA, the Maryland States Attorneys Association, that this bill could lead to a host of new reversible issues in cases, and that's not that would not be the case. There are currently certain questions that are black letter law that the Maryland Supreme Court has said if you don't ask these questions, it's reversible. This bill doesn't change any of that. Those reversible issues are still as they are, but it doesn't add a whole new class that ultimately a judge's decision whether to ask a question or not, as Judge Grimm stated, is going to be in that trial judge's discretion. It would get reviewed for an abuse of discretion. So for those reasons, I urge you to pass this bill.
Thank you. Carrie Hansel, are you available online? Okay, great. We have one more favorable, and then panel will go ahead and open it up for questions after Ms. Hansel. Or Mr. Hansel. There you are. Hi, Mr. Hansel. You may begin when you're ready.
Thank you kindly. My name is Kerry Hansel. I appreciate the work of the committee on this issue. I am testifying very strongly in favor of it. I'm a civil rights lawyer. I also do appellate work, and I want to follow up on this idea that somehow this is going to increase the number of appeals in Maryland. That simply is not true. It's not true for 3 very clear reasons. The first is that this bill leaves within the discretion of the trial judge the questioning of the jury. The second is that that discretion is reviewed on appeal under the very highest standard in Maryland law, which is an abuse of discretion. The third is that in addition to a legal error, in order to successfully appeal, we must also show that that error was prejudicial. In a case like this, that means I'd have to show that if we asked a question the judge didn't, that a juror would have responded, that if the juror would have responded, I would have stricken that juror, that if the juror responded and I struck the juror, that it would have somehow upset the balance of what was otherwise a unanimous opinion in one direction. The likelihood of convincing an appellate court of those things is extremely minimal. And as a result, when people come to me as an appellate lawyer and ask about their odds in a case like that, I'm going to tell them that is not an appeal worth filing, and this is not going to lead to any appreciable increase in appellate issues. Now, in the very few cases where those needles could all be threaded, we're talking about protecting people's constitutional rights in the extreme circumstance of an abuse of discretion, an error I can prove on appeal to be prejudicial. In those circumstances, well, then the right to an appeal is a feature, not a bug, because what we're here about, after all, is justice and not just ease of prosecution. So I would urge a favorable report. Thank you very much.
Thank you. Are there any questions? Okay, seeing none.
Thank you.
Thank you very much. That concludes the favorable panel with respect to House Bill 1079. For unfavorable panel, we have Michael Stewart from the Maryland States Attorneys Association. And Mr. Stewart, whenever you're ready.
I'm ready, Madam Chair. Thank you, members of the committee. As you might notice, I am not Steve Kroll, but here I am anyway. I will say I'm asking for an unfavorable report on House Bill 1079 from MSAA. Once again, I'm Michael J. Stewart Jr. I am special counsel to Haven Shoemaker in Carroll County. If we're going to talk about how old we are and how long we've been plotting the earth and practicing, I've only been practicing 31 years. I've had a cup of coffee as a state's attorney. For 30 years, I wore the black hat as a defense attorney, as we say now. And I can tell you the concerns I have are the same ones MSAA has. The first concern is, you know, this is a laudable bill. Everyone should have a fair trial, not a perfect trial. They don't exist anywhere, but I will say we need to read legislations when we pass it, and the language says the purpose of jury examination shall, it's mandatory, allow the parties to obtain information that. So, you know, that takes it out of abuse of discretion. That's a legal requirement that if certain questions aren't asked and at a certain time the judge decides to cut it off, that's not going to be an abuse of discretion review. That's going to be you made an error of law review, and it will encourage that. And I will say this again too. Let's talk about when somebody's tried for an incarcerable traffic offense that would be an hour jury trial. I can imagine realistically that you don't want jury selection to last 2 or 3 days when the trial would be a morning. And you could see that, because if I was wearing the black hat, you betcha I'd ask the Spanish Inquisition all day long until the judge cut me off if I could. So I'm just saying the unintended consequences of this will increase the actual time it takes to pick a jury. And I will say this, in 30 years, civil trials I've done, I have a different opinion, but I will say this, I'm at the opinion now, the Lenny Shapiro, who I respect, who's a great litigator, is like, after I get somebody with an axe to grind through voir dire through cause, seat the first 12 and then give me 2 alternates, because if I could really get to what you're thinking and how you're going to do, I'd quit my job and I'd go to Laurel at the racetrack. So I'd ask you to oppose this in an unfavorable report. Thank you.
Thank you,
Any
Mr. Stewart.
questions?
Don't go anywhere. That's my job. Are there any questions? Well, as such a young lawyer for only 31 years, I did want to ask you to expand just a little bit on what you were saying about the section of B, which says the purpose of the jury examination shall be to, and you were saying that it would be a question of law. Can you just kind of go into elaborate on that?
Yeah, because right now, before this bill, the voir dire questioning is basically the province and discretion of the trial judge. And appellate courts give great deference to exercise of discretion. It's got to be an abuse of discretion standard. And in all deference to people who do appellate work, I see every day people file appeals that have no chance at all, but they still file them nonetheless on grounds, and it does clog up the legal system. I'll just give you an example because there's a different story. If you are being, if you're being charged with an offense, it can be like murder, where you could get life. You get as a defendant 20 peremptory challenges. The state gets 10. Between 20 years and life, it's 10 and 5 in favor of the defendant, and then it's 4 and 4 for what we call most stuff that happens. But I can tell you how much questioning and how much better is your jury going to be in a theft case, a theft under case of, you know, a certain amount, when you only get 4 peremptories, and that, you know, people that don't want to be there now, it's hard to get them there. It's hard to get them to ask, and they're going to be grilled over that for 4 peremptories, which may or may not help, by the way. And at the end of the day, what's going to happen is you've got people there. Let me put it this way. If you want to do a simple theft trial, it's 60 jurors in the array. If you want to do 20 to life, you probably need, because of the peremptories, 60 to 80. A murder trial, you need like 120 folks off the motor voter rolls who come. That takes a long time, and people get tired. They clam up. And like I said, there's only so much you can get out of people to get a jury as far as, and most of the stuff most people are honest to the questions that are asked. The voir dire questions that are asked in a typical trial can be 50 questions already. And they're called up one at a time, and the judge has great discretion now to weed out someone who has an axe to grind or not grind. So to add this on, what I'm saying is you're going to lengthen trials. You're also going to create multiple, and I'd do it if I was wearing the black hat today. You have multiple avenues now for another appeal. Yes, you should have asked that question. You shouldn't ask that question. So
Okay,
I hope that's helpful.
thank you. Are there any other questions? Delegate Taylor?
It just occurred to me that in the prior panel, there was mentioned that the federal courts already use this process. So
well,
why wouldn't we?
The federal courts do use this process, and it can be allowed in civil cases too. In Maryland, we only have 6 on a civil jury, and where it's a lot more complicated, you got contract stuff and this and that. Judges will let you go a little. I've done these trials where the judge will let you do a lot of the voir dire and stuff, but the federal system is prefaced on not trying cases. They weed cases out left and right. They get rid of them at the drop of a hat. Whereas the district court system we have in Maryland, you get a jury trial. If you get 90, if you're facing 90 days or it's common law jury, you get a jury trial. If you get a de novo appeal, even if you couldn't get a jury trial below, if it's 1 day imprisonment on the line, you get a jury trial. So as far as it goes, you'll have situations which they don't face in the federal courts and then they weed these cases out, scheduling conferences and the like. Our cases, you're looking at somebody gets caught driving on a revoked license who can get a jury trial up in the circuit court. And like I said, that's a 2-hour trial. But if we want to go down the road of the Spanish Inquisition to go ahead and give the census questionnaire to every possible juror, the trial could be days. Picking a jury could last 10 times longer than the actual trial. Right now, there's a trial where we are. It's a conspiracy to murder trial. There was over 100 folks. It took 2 days to sit that jury, and it's a slog. And you want people to come and answer honestly to that, good luck. Because like I said, MSA says one thing, this bill, you should weed out implicit bias if you can do it effectively. But I'm saying is when the black law goes on the page, you have to live with the unintended consequences in the real world where the rubber meets the road. And I'm telling you, they can poo-poo all you want, and it can be numbers, and maybe I don't know what I'm talking about, but you want to come back next year if you pass this and we say how long it takes to pick a jury, we'll keep stats because I'll see it every day.
Okay, thank you. Delegate Simpson, unless you had a follow-up, Delegate Taylor. Okay, Delegate Simpson.
Have we ever thought about modernizing our system at all and testing people instead of doing this same old thing that really, who knows where you're going with it? I mean,
look, I can say this. I've been a prosecutor for a year and on both sides of the fence, and I've sat there after verdicts and I've scratched my head and said, what did they do? The vibe and this and that, but like I said, we have AI now. Maybe we ought to let AI develop questions and pick a jury and just take it out. But I can say this: we've been doing this since the Magna Carta was signed, right? And it's valuable because you know what? I think jurors, the way I've looked at it, I think jurors these days, particularly with television effect, everything else, they pay particular attention to the proof that we have to adduce these days. They want to see DNA, they want to see video. They hold us to a high standard. I mean, back in the day, I can remember the days when I first started practicing that a police officer would testify, and if the police officer said it was gold. That person got convicted. And then the thinking was, hey, if they didn't do this one, they did something else. But these days, I'm telling you, I can see, you watch these jurors, you see verdicts come back and you talk to them. And sometimes the jurors want to talk to us and say, what did we not see? What did this? And like I said, the people who get put on juries these days, they take their instructions seriously. They hold our feet to the fire. But like I said, you can ask questions till the cows come home and you think unless you've got some empirical data and this and that, like I said.
That's what I'm asking about. Is there is there data out there, research that actually tests what, we've been doing this since the 1700s. You all look very nice, but really, can we use maybe some science to figure out the best juror?
Well, if that's the case, then I urge you not to pass the bill as is and form a study group.
We love study groups.
Well, I'm just saying, and if you vote for it, I heard you got to sit on it, so.
Right. Okay, so Delegate Cardin.
Thank you, Madam Chair. Thank you very much for being here. So first of all, isn't the purpose of voir dire to identify and possibly remove jurors who are unable to serve? Isn't that the goal of voir dire?
Well, it's two parts. I mean, we've got the legal requirements to serve, which should be rooted out by the jury commissioner through a questionnaire. And then we have try to put out people like, say, my next door neighbor shows up at a trial. We don't want
the question is, wait a minute.
Yeah.
Jury examination. I'm not talking about whether.
No, I'm talking voir dire right
determining
now.
Whether they're appropriate to be acceptable to be put in the jury pool. When we're
Yes.
talking about jury examination by a judge.
Yes.
Isn't the purpose to figure out who is unable to serve because to be a fair juror? Isn't that the purpose?
Well, that's the case law in Maryland right now. You'd be changing because that is the only purpose under the case law is to make sure that the person can deliver an unbiased verdict based on the evidence and facts presented before them following the instructions given by a judge.
So the goal, so we agree then the goal is to make sure that they can be fair jurors.
Absolutely.
So the problem with saying that the purpose of jury examination shall be to make sure we're finding jurors, we can agree that that should be the purpose. It's not, well, it may be able to find a fair juror, may not. No, the goal is, we're not perfect. You already said that. But the goal is to try and weed out jurors who are biased.
A laudable goal, but the question is, are you going to reach it with this?
That's not where I'm going. I just want to make sure. If we decided to, and it's, by the way, it's the judge who makes the decision on whether he asks these questions. So you keep talking about, I mean, you've talked now for like 15 minutes. The judge would have cut you off by now, right? And said, no, I'm going to ask questions.
I was answering questions, Delegate.
So the next question is, and the last question, if we pulled out criminal out of this, would you even be here? We just made this civil?
Actually, I have done civil practice also, and I do complex procurement law was part of my practice. And yes, in civil law, a lot of judges, because of the complex nature of what has to go before a jury, they will let counsel basically ride the bus on voir dire, and I've done it. And yes, it's
so the answer is yes, then you would be okay with it if it was just with civil. I think
in the civil end, probably.
Okay, thanks, Madam Chair.
Okay, thank you. Seeing no further questions. Thank you very much. That concludes the testimony on House Bill 1079. We're going to move now to House Bill 1392 with Delegate Tomlinson.
I don't have a lot of testimony, but he's up again.
Oh. Mr. Stewart, you're welcome. You're welcome anytime. Okay, so we're gonna. All right, Delegate. So I've got Adam Wells. Yes, Mr. Wells? Yes. Okay, great. All right, so Delegate, whenever you're ready.
All right. Thank you, Madam Chair, honorable members of my home committee here. Good to see everybody. For the record, my name is Delegate Chris Tomlinson, and I'm testifying on House Bill 1392. I have yes. So the first part of this bill, just to get us started here, I am complete. Is the part that I'm keeping. The second part of the bill, I'm amending off. So if you've looked at any of the testimony, most of the testimony is related to establishing a THC level. That is all. An amendment should have been was distributed earlier to the committee and hopefully got out to everybody. So the bill is at this point only pertains to the first part, which is the part about the drug recognition experts and the Dahlberg decision. So as some of you might know, the Rochkine versus Stevenson decision back in 2020 with the Court of Appeals in Maryland, now the Supreme Court of Maryland, they held that the Daubert standard will replace the general acceptance test for the admission of all expert testimony in Maryland. This means that DRE's drug recognition expert testimony is now fair game for public defenders and private defense counsel to challenge under Daubert in all of Maryland's 24 jurisdictions. This bill will allow trained and certified DREs to opine that someone is driving impaired due to a certain drug and that the opinion is admissible under Daubert. If this doesn't pass, one or all jurisdictions in Maryland may lose their ability to use DRE testimony for years while this is all sorted out in the appellate courts. Next, you'll be hearing from some folks here from the Carroll County State's Attorney's Office who can provide some more information, details surrounding the history of this and the legislation. But I'm happy to answer any questions from the committee, and I look forward to a favorable report. Thank you, Madam Chair and fellow members of the House Judiciary Committee.
Great. And so you all are were originally testing favorable with amendment.
Madam
based on the
Chair,
amendment that that Tomlinson, okay.
Madam Chair, we are testifying, asking for a favorable report as amended, as a friendly amendment, because we had consultation with law enforcement, the MSAA and state police conversations, we decided that we'd support their positions too, which is that. And if I may be brief, if I can in this one, Delegate Tomlinson put it succinctly. We're asking for a legislative fix to something that the Court of Appeals, the Maryland Supreme Court, upset the apple cart and basically several years ago adopted the Daubert standard for expert testimony admission. Daubert's been around since '93. It's accepted in federal courts most other places. Daubert is widely, the DRE program, drug recognition expert, can opine just about every state, every jurisdiction in Maryland that someone is impaired for a certain drug while driving a motor vehicle. This hasn't changed. That's been accepted under Daubert many places. I've brought Adam Wells, who's our vehicular homicide head at Carroll County, and he lives and breathes this stuff, and he's going to explain to you why this changes nothing except for the fact if we don't get this legislative fix, you could be without a tool that's currently used by law enforcement across Maryland to take impaired drivers off the road while this twists and turns in the appellate courts. And I'm going to turn it over to Adam now.
Good afternoon. As Mr. Stewart indicated, my name is Adam Wells, and I'm the Vehicular Homicide Unit Chief for the Carroll County State's Attorney's Office. In that capacity, ladies and gentlemen, in 20 years of prosecution, I personally see and deal with the scourge of drug driving and the horrible carnage it creates probably on a weekly basis. So the question is, why should you support this bill? The DRE protocol has been around and in use since the 1980s. This has been tried, true, and tested for almost as long as I've been alive. This is not a new protocol. To date, every single state in the nation uses the DRE protocol, every single one. Case law nationwide overwhelmingly supports the protocol. No state has discontinued it, and not one state's highest court has ever nullified it. The protocol is endorsed by a number of professional organizations. It's not just law enforcement. The American Medical Association, the American Optometric Association, the American Bar Association, NHTSA, International Association of Chiefs of Police, just to name a few. Recently in New Jersey, they held a hearing on the very same issue that we're talking about using the new Daubert standard that Maryland uses. That hearing was a monster. It was 42 days of testimony. There were 16 witnesses that testified that were experts, and they reviewed over 5,588 DRE reports to determine whether or not the Daubert protocol, or excuse me, the DRE protocol satisfied Daubert. The result from that was that yes, it does. Also, for the results where the reports had the corroborating blood test, it showed that they were up to 90% accurate with their opinions. This protocol is established and has been for a long time. Now, the question is then raised, why do we need a bill on this? And I'll tell you, the basis is the state cannot appeal this at the trial court level, and the defense won't. Statutorily, the state can only appeal certain things, and if there was a hearing and the state lost, we cannot appeal this. We have had these issues in the past under the old standard, Fry-Reed, and the state won in Crampton and in Wood v. State, Calvert and Montgomery, and the defense would not appeal it because then it allows them to raise it again and again and again. Based upon that, we ask for a favorable report, and thank you.
Thank you. Are there any questions? Delegate Grammer?
Thank you, Madam Chair. Is there part of the protocol to set up to corroborate or refute the opinion of the DRE?
Absolutely, Delegate, and thank you for the question. The protocol itself is a 12-point standardized protocol, and the last part of it, the 12th part, is when the DRE requests a corroborative blood test from the person suspected of drug driving. So when the blood test is done, they then can either corroborate, or if the DRE is incorrect, refute the testimony of the DRE. So this is not just us asking that, hey, can you put this DRE up there, and you're forced to accept his opinion. No, there is the opportunity for a blood test. And I'd like to reiterate, based on the 5,588 DRE reports under just the New Jersey opinion, that was up to 90% accurate. So thank you.
Delegate Valentine.
Thank you, Madam Chair. Thank you, Delegate, and thank you, panel, for coming in today. Has this protocol been addressed statutorily in Maryland previously?
Yes, actually, under the traffic article 16-205.1, it has been raised previously, not on this particular issue. It doesn't say specifically that the DRE protocol shall be admissible and is accepted science. What it does do is, let me back this up a little bit. For a regular DUI, person is pulled over, they're run through field sobriety tests, and if there's reasonable grounds to arrest for alcohol, the road trooper can then ask, will you submit to a chemical test of your breath, or under the circumstances for a chemical test of your blood? Under 16-205.1, the legislature agreed that the only person who can even request for a blood draw is somebody who has completed the DRE protocol. So there is already a tacit admission by the legislature that they agree with this protocol. Additionally, you have to understand that without this part of the bill to follow up with it, it would mean that the legislature would require that a DRE, and only a DRE, would be able to ask a person to submit to a test of their blood to determine if they're impaired, and then in the same breath say, but you know what, we're not going to admit the basis for your knowledge to request that, which would make no sense. So that is one of the reasons why we're asking for this specifically. Now, the last part I'd like to touch on is with regards to what I was frankly kind of ran out of time with. This will never reach an appellate court because we can't appeal this. If we win, we can't appeal it. And when the defense has lost, they won't appeal it because they know, and I don't blame them, tactically, what they can do then is just say Carroll County. If they won, if we won, they wouldn't appeal it. And under Judge A, that doesn't mean anything. That's not binding. In our same jurisdiction, they could come back next week and challenge the same thing again in front of Judge B. And then the week after that, Judge C. It will never go up because they won't want it to, and we can't. That's why it's important, and that's why we're asking for your support.
Any other questions? All right, seeing none, thank you very much.
Thank you. Thank you.
Go now to those in opposition to the bill: Haley Mulder, Caitlin Kokoma, and Andrew Northrop. Whichever one of you would like to go first.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the committee. My name is Dr. Haley Mulder, Chief Toxicologist for the Maryland State Police Forensic Sciences Division. And I would like to thank you for the opportunity to provide testimony regarding House Bill 1392. And I would just like to mention that I am going to be testifying in regards to the amended part that's going to be removed. The implementation of the requirements outlined in House Bill 1392 causes great concern. The bill mandates that the results of the chemical test for delta-9 tetrahydrocannabinol, or THC, with a concentration of 5 nanograms per milliliter or more, be deemed prima facie evidence that a person is impaired by THC. Whereas alcohol is soluble in water and the concentration in blood can be correlated to the concentration in the brain and its reported effects, THC has different interactions within the body that make it difficult to make those same correlations. Impairment by THC is instead established through an officer's observation of the driver at the time of the traffic stop and is supported through chemical tests of blood for the presence of THC and its metabolites. The conclusions of either investigation alone is not enough to conclude impairment of an individual by THC. To marry THC impairment to a single number, such as 5 nanograms per milliliter, is misleading. Numerous clinical studies have shown that there is no threshold concentration of THC in blood that indicates impairment. With the legalization of cannabis across the United States, it has been shown that consumers of cannabis can have baseline levels of THC present in the body above 5 nanograms per milliliter, even after the cessation of smoking for over 24 hours. As such, establishment of a per se law or a zero tolerance policy for THC is discouraged by the forensic toxicology community until there is a better correlation to THC consumption and impairment. And so in conclusion, while ensuring road safety and combating impaired driving is paramount to the mission of Maryland State Police, a per se limit for THC as outlined does not adequately address the drug driving problem in Maryland. And we urge the committee to consider an unfavorable report in regards to Section 2 of House Bill 1392 and consider appropriate amendments removing the specific requirements. And we'd like to also thank Delegate Tomlinson for announcing those amendments. Thank you.
Good afternoon, members of the committee, Mr. Chair, Madam Vice Chair. My name is Katrin Kokoma. I'm an assistant public defender with the Office of the Public Defender. And on behalf of the Public Defender's Office, we urge an unfavorable report on House Bill 1392. I've been with the Public Defender since 2019. In that capacity, I've been assigned to the Anne Arundel County Office first as a district court level attorney and currently as a member of our jury trial prayer unit at the circuit court level. While in both positions, I've handled numerous DUI and DWI cases. And I'm here to offer a little bit of practical perspective on these bills. I understand that the section that is now being amended, we would also be opposed to that, in particular because a law that would be imposed that can be so clearly countered by science would simply result in more trials rather than fewer, because not only would individuals who are legally permitted to consume cannabis be at risk of their liberty when, as the science shows, there's no actual strong correlation between consumption and impairment, but also it would likely result in defense attorneys like myself calling experts to counter easily impeachable information like that. As for the section permitting an officer trained in the drug recognition type program to opine on the ultimate question of whether or not someone is impaired by drugs, controlled dangerous substance, and or alcohol, I would note that it currently contradicts the law of expert testimony that is in place. My colleague, Mr. Northup, will address this in his testimony as well. But as recently as last week, I was working on a case where a drug recognition expert was called by the state. We went through the same protocols as any matter and having that individual determined as an expert. Second, it would also result in what we call a battle of the experts. Most of these cases are heard at the district court level. Those trials are heard by judges, and those would, I urge an unfavorable position, Your Honor. Thank you.
Did you just say Your Honor?
Your Honor, I'm sorry. And yes, Mr. Commissioner.
Oh,
I would promote you in our other capacity as well.
it's very kind. Mr. Northrop, please.
Thank you very much, Mr. Chair. My name is members of the committee. My name is Andrew Northrop, and I am a public defender in OPD's Forensics Division, and our division handles and evaluates forensic evidence that the government seeks to introduce in court. And as Ms. Kokoma stated, we're seeking an unfavorable report on this bill. While keeping impaired drivers off the road is an important goal, this bill is not the way to do it. Legislation and policy should be based on science. Cases should be ruled upon based upon their individual merit and the evidence in those cases. This bill precludes a court from making each individualized determination assessments with blanket rules on admissibility that are not based on science or evidence. As we've talked a lot about Daubert, but I want to be clear about this. The issue is that the fact and case-specific inquiry should not be hamstrung by legislation, however well-meaning, that interferes with the gatekeeping function that Daubert puts upon the court. Under this statute, a police officer with the qualifications set forth herein would automatically be able to render expert testimony. And you heard talk about the protocol, but under the statute, the protocol wouldn't even need to be employed. The statute does not require any kind of reliability methodology to be used. or that the individual be proficient or current in the field, since it only requires successful completion of a DRE training program. The statute doesn't even allow a judge to make a determination that the evaluator has the competence to do the job correctly. And as we stated, that because like the THC limit, because THC has absolutely nothing to do, like the levels have no basis for impairment as previously stated. And while I'd like to say that drug driver is an important issue to address, but we have to do so with laws that have scientific basis and that do not interfere with the court's individual ability to make individual assessments. Because one of the things you'll see about these cases is that they're complicated. And you have situations where individuals have medical conditions or other things that may mimic drug impairment that aren't. And that's one of the things that needs to be assessed by a judge, and just being able to make sure people have the qualifications to do so. Thank you.
Delegate Boucher.
Thank you, Mr. Chairman. Thank you, panel, for being here. I'm trying to envision that if this bill becomes law, could a jurisdiction train all their law enforcement officers to be experts at this? And then someone gets pulled over, smells like cannabis, then all those officers could just testify against that individual, that because they're an expert now, that person was driving under influence?
I believe so. That is our understanding and reading of the law as it currently stands.
Thank you.
This bill doesn't require any sort of recognized methodology. It pretty much says if you've graduated the program, even if you graduated 20 years ago and haven't kept current, you still are able to evaluate somebody and declare somebody impaired.
Mm-hmm.
Delegate Valentine.
Thank you, Mr. Chair, and thank you, panel. That brings up an interesting point. If you are stopped and subsequently arrested in Maryland for a DUI, that arresting officer cannot administer that test, correct? A breath test if they consent to a breath test?
Correct.
So wouldn't this fall under the same? It's my understanding of DRE is only utilized in cases in which they are separate from the actual stop and or the arrest process, so that does not come into play? Is that not the case?
If I may, I actually had a case a couple of weeks ago where the DRE was the stopping officer and the DRE conducted the DRE evaluation. So all those laws about the DUI officers are very explicitly set forth. But to my knowledge, there's nothing establishing that separation for the DRE.
It may not be in statute, but it's my understanding that does not occur now presently.
It occurred in a case I was working on a couple of weeks ago. So I can tell you for a fact that it's occurred at least once in Maryland.
Thank you.
Are there any other questions related to the bill for this panel? Members of the committee may remember that Mr. Northrup and I went to college together at a place called Earlham College in Richmond, Indiana. Mr. Northrup, what is the central part of the campus called?
I believe it's called the Heart, Mr. Chair, or should I call you Your Holiness?
Yeah, that was at Earlham. But so anyway, I understand that there's going to be an eclipse that goes through Richmond, Indiana on April the 8th. So would that make it a total eclipse of the heart?
I think you're here all week. Try the pepper steak.
I appear to be losing the room. All right. Thank you very much. That concludes, thankfully, the testimony on House Bill 1392. Thank you very much for your testimony. All right, we're going to go now. Thank the committee for their indulgence and for the abuse I'm going to take later. House Bill 296, please. House Bill 296 with Delegate Grammer.
Thank you, Mr. Chair. I welcome anybody who'd like to testify on the bill. With your permission, I'll get started. Thank you, Mr. Chair, Madam Vice Chair, members of the committee. For the record, the Delegate Robin Grammer here to present House Bill 296. House Bill 296 protects the firearm ownership rights of those who qualify to use medical cannabis by reconciling the public safety and health articles. If you are a patient who qualifies to use medical cannabis through Maryland's Medical Cannabis Certification Program, you lose your rights to purchase or own a firearm. In response to the passage of Maryland's Medical Cannabis Program, the state police wrote to Attorney General Brian Falsh for guidance on several policy questions, including direction of the Maryland State Police and the statutory responsibility for firearm applications, licenses, and permits. Attorney General Frosch responded, "State law does not permit Maryland State Police to deny state purchase applications, HQLs, and wear and carry permits to qualifying medical cannabis patients based solely on those patients' use of medical cannabis in accordance with state law." Attorney General Frosch elaborated Section 133313A of the Health General article mandates that a qualifying patient in possession of a legal supply of marijuana under the medical cannabis program may not be denied any right or privilege on account of that person's use of medical marijuana, and expanded, "The best way to harmonize these statutes is to read the right or privilege provision in 133313A to create a limited exception to the HQL statute such that the Maryland State Police may not deny a license to qualifying medical cannabis patients solely on that ground." And that's what this bill does. Prohibition of marijuana is over in our state. We need less illegal guns and less illegal drugs on our streets. We can achieve that by providing legal pathways for Maryland in this bill. I'm happy to take questions, and I'd ask for a favorable.
Good afternoon, and thank you to Delegate Grammer for sponsoring this bill, to the chair and vice chair, and to members of the Judiciary Committee for allowing me the opportunity to express my organization's favorable support of HB 296. My name is Shanita Marable-Lewis. I have a master's degree in medical cannabis science and therapeutics. I am a proud Army combat veteran, and I am the executive director of Veterans Initiative 22, a nonprofit organization whose mission is veteran suicide prevention. One way in which we support our mission is by providing veterans with free medical cannabis certifications through partnering qualifying providers. Ironically, I cannot take advantage of the very service that I work daily towards providing my fellow veterans because I do not want to infringe upon my right to purchase, own, and possess a firearm. Many veterans share this same sentiment, as is reflected daily in my conversations with other veterans about our organization and the services we provide. I am repeatedly told that the Second Amendment issue is the deciding factor for why a veteran has chosen not to get a medical cannabis card. Simply stated, vets do not want to lose their gun rights, nor should they have to choose between a safe treatment for their health or the ability to protect themselves and their families. I find it quite a travesty that the very population our government spends millions meticulously training to be responsible marksmen are told that the medicine that they are lawfully consuming to mitigate symptoms from the injuries sustained during their service will ultimately make them ineligible to legally own or purchase a firearm. A survey conducted in 2017 reported that 22% of the 16 million veterans in the U.S. stated that they are currently using cannabis to treat a medical condition. 40% of caregivers stated the same. Our esteemed Governor Wes Moore dedicated 2024 as the year of the military family. Well, I can think of no better way to honor our veterans than by restoring their constitutional Second Amendment, a right that was wrongfully stricken from a right that was taken based solely on old outdated science to sustain stigmas and just plain old reefer madness. Thank you.
Go ahead.
Good afternoon, committee. My name is Randall Cody Floyd. I'm not here on behalf of any organization. I'm just here as a Maryland citizen addressing why we should pass this House Bill 0296. I'm a current resident of District 2A. I am 100% disabled veteran of the Army, and like she was stating, basically, I chose my medical cannabis card over my gun rights, and I should not have to do that.
I don't know if he wants me to do it now.
If I was to obtain a wear and carry permit right now as a military veteran, I'm actually exempt from taking any shooting proficiency courses that the state asks of you to get that permit. But because I'm a medical cannabis owner or holder, I can't have a gun, period, which basically saying that I am not competent to hold a firearm. But according to the U.S. military, I'm very proficient in firearms training. I take medical cannabis for a lot of things that erases almost 9 different medications out of my cabinet to settle with one thing that doesn't harm my body. Now, what right now under current law is saying is that if I was to go back and switch from my medical cannabis card to go back to opioid painkillers, which I am 8 years sober from, that I would go back to that, and I would be a legal gun owner. I can get my carry permit with prescription opioids or painkillers. But for something that I choose that's less harmful route, I can't own a gun. Why is that?
Well done. Well done.
Mr. Chairman, I'm here as informational only. If you want to take questions versus panel.
We'll hear from Renee Reisinger then, please. You have to unmute yourself, though.
Hello, hi.
Go ahead.
Thank you for letting me speak. I've been in the cannabis industry in Maryland since 2017 as a nurse and a nurse practitioner, and I've seen the healing properties of cannabis. Like our veterans said, I'm also with Veteran Initiative 22, and Ms. Lewis and I both graduated from University of Maryland School of Pharmacy master's program. So even our state universities are supporting the use of cannabis as medicine. And like our veteran, the gentleman to the left of Ms. Shanitha said, he can use alcohol or opioids, but with cannabis, he's restricted from having a gun permit. And in the spirit of trying to improve public health outcomes, we want to support our veterans, our law enforcement, our first responders. All these groups of people hold the right to be armed and carry a weapon near and dear to their heart, and it precludes them being able to use medical cannabis. And I think with the Judiciary Committee, you want social justice, and a social justice initiative that you want to move forward with is to remove the restriction of the concealed carry with medical cannabis. Thank you. It removes the restriction of the concealed carry.
You have Sergeant Bond, please. Maybe frozen. Yeah, it appears he's frozen. We will come back to him if possible. If there are questions for this panel, we'll go ahead and take them. Don't go in, well, okay. Well, if you had a question for Ms. Reisinger, it's too late now, but that's okay. Delegate Phillips.
So I'm sorry, your name, sir?
Oh, I'm Cody Floyd.
Mr. Floyd. Your comment for me was a drop the mic moment, but I've got to ask you this. Do you feel more under control when using cannabis or when using opioids?
Absolutely cannabis 100% all day, and I will stand by that. When I got out the military, I fell into a very bad opioid and drug habit. Oh, I'm sorry. I fell into a very bad opioid and drug habit. Cannabis has been helping me for 8 years stay sober off of opioids and painkillers. But that doesn't make me a bad person that I'm not allowed to own a firearm. I've restored my gun rights, and I should be allowed to have those gun rights, not because that I'm a medical patient.
Thank you.
Yes, sir.
Thank you.
No, I'm still mute. All right, maybe Mr. Bond is back with us.
So he's actually in the same room with me. He's my veteran husband.
Oh,
I can turn.
Why don't you ask him to come to your, that's better.
I'm doing that now.
There you are. Okay.
There you go.
Why don't you speak for 2 minutes then? That's fine. Go ahead.
Right.
Thank you.
Thank you. My name is Richard Bond. I'm a retired Army veteran of 25 years. I'm also in Veterans Initiative 22 and Americans for Safe Access. And I would hope the committee would have a very favorable action for this bill. You know, cannabis is medicine, and we shouldn't slight anybody for trying to get a better quality of life, you know, in my eyes. So I would appreciate you looking very closely at this bill. Thank you.
Thank you.
All right. Mr. Panak, if you'd like to go ahead and provide your testimony, that'd be fine.
Thank you, Mr. Chair. Mark Penlick, President of Maryland Show Issue. I'm not in opposition to this bill. I'm here purely as informational only. All the shoulds you heard today, I'm completely agree with. And my heart goes out to the military veterans who find cannabis helpful. And I'm not opposed to any of that, but I'm here to point out the legal reality, which is on the back of my written testimony, you will find the current form 4473 that the ATF mandates that every firearms dealer uses and the state police uses to actually authorize background check and to acquire a firearm. Federal law, and I refer you back to item number 21F, and I'll quote it to you. If you are an unlawful user or addicted to marijuana or any depressant or any other controlled substance, warning, the use or possession of marijuana remains unlawful under federal law, regardless of whether it's been legalized or decriminalized for medical or recreational purposes in the state where you reside. You may not legally, under federal law, answer that question that you are not an unlawful user. And if you do, that's a federal felony. So you can get an HQL, you can go out and buy a handgun, you can go out and buy a long gun. And if you do, you have to answer this question truthfully. And if you don't, that's a felony. So the state can make all the laws it wants to legalize this stuff. And I'm fully sympathetic to it. But what you're doing, and I would direct you to the last paragraph of my written testimony, is you're misleading people potentially into thinking it's legal when it's not. And people are getting pulled over on the BW Parkway by federal law enforcement officer, and they're getting, this provision will expose them to arrest because it's illegal for a person who's a user of marijuana in Maryland, illegal under federal law to possess a firearm. It is illegal to carry it. It is illegal to have it with them. They may not carry it. They may not buy it. They might not possess it. So I urge you to at least think about that in the context of what you're promoting here. Thank you.
All right, Delegate Conaway.
Thank you, Mr. Chairman. Thank you, delegate and panel, for coming in to testify. To the good delegate, it looks like you disagree with some of the statements that was made.
Yeah, this is the question. What I'll do one day is I'll show you the opinion of Attorney General Frosch. It's 25 pages. It's really fantastic. And the state police asked him, what do we do with this question? And he cited the 10th Amendment to the Constitution as to why it's legal for Maryland to permit people to own firearms. And the question, there's a twofold question. Well, we've got these federal laws. Well, the federal government can enforce them if they like. But what you're seeing as not only medical cannabis is legalized across the country, but adult cannabis is legalized across the country. The federal government's not enforcing that law. They're not arresting people. They're not seizing assets. They're not shutting down industries. Now, the second question is about this. What do you do when you get one of these cards? And what do you do when you go to your local gun shop and you answer that question and they deny you the ability to purchase a firearm? And what the Attorney General said is what I agree with, and it's what this bill does, is it directs state actions. It directs the Maryland State Police. And it reconciles a couple statutes that say folks who have medical cannabis cards cannot be denied their rights. So I think what he's saying is accurate. I think what he's stating regarding federal law, yeah, they can enforce the heck out of it. But what president has shut down local state medical or adult use industries? And that's the difference. And that's why I believe this bill is legal.
That's pretty good. So if a car is coming down the Baltimore-Washington Parkway, which part of it is still in Maryland, I believe, and they're stopped and they have that card and they have a legally purchased firearm in their car, what do you see that would happen with that kind of situation? Because they're going to be stopped by the what do you call Parkway Police? Park Police, sorry.
The question is, what does the federal government do? What does the state government do? I mean, technically the state police could come into your house if you have a card?
State police, we're talking about on the Baltimore-Washington Parkway. Yeah, Park Police, when they stop you, that's federal, right? But it's coming through the state of Maryland. So a person that could be a state citizen,
right,
could have a firearm legally purchased, could have
right,
a card, could have just left from Silver Springs or something with their THC or whatever, and they're on the parkway. What do you think is gonna happen if we pass this bill?
If we pass this bill, the irony is that people can get a carry permit with a card. You can carry a gun with a card. The irony is you can't buy one.
So just to elaborate on this point, the 4473 is filled up with a gun dealer for long guns. The state police is not involved in that process. So the dealer will not sell a gun if you answer yes on that question. It is prohibited by law, and if he does, he's going to lose his ATF license as a FFL. And he may be an accessory to an illegal acquisition that's a federal felony. So they're not going to take that risk. That's the hard reality.
Seeing no further questions for this panel, that concludes the testimony on House Bill 296. Thank you very much. And we'll go now to House Bill 684, please.
I do not have a panel on this one, but if there are anyone who wants to testify, I'd welcome them up. And I'll get started on this with your permission.
It's just you, but okay.
Okay, Mr. Chair, Madam Vice Chair, members of the committee, again, the delegate Robin Grammer here to present House Bill 684. House Bill 684 modifies the culpability standards for illegal possession of a firearm. A young man named T that the Office of the Public Defender said carried a firearm as a matter of self-defense. The Towson rapist who used the .38 caliber handgun in the rape of 3 women. Sean Harity, who was prosecuted in the case that the Baltimore Banner titled A Complete Lie. These are radically different cases that share one aspect. They were all subject to the penalties under the crime of illegal possession of a firearm. This bill attempts to modify the culpability standards of the charge to differentiate between these radically different offenses. The bill applies the knowingly culpability standard to all offenses listed under a legal possession statute. This changes and differentiates the person who has mistakenly violated Maryland's permit law from the person who purposely violates the statute. The bill removes the language or about, as in or about the person. This is known problematic language both in enforcement and prosecution, and it has been legally challenged in Lawrence versus the state of Maryland, and the courts have noted that the General Assembly should consider this exact language. The bill removes the rebuttable presumption that a person who transports a handgun violates the law knowingly. Such a presumption is a clear violation of rights. And finally, the bill creates a monetary fine for first-time offenders who have simply violated our permitting laws. Folks who mistakenly violate permitting laws should not be prosecuted as if they were violent offenders. Our culpability laws should reflect that desire. For that reason, we should pass this bill. I'm happy to take questions, and I'd ask for a favorable on House Bill 684.
Thank you very much, Delegate, and you can go ahead, Jimmy.
Thank you, Madam Chair. Mark Pennock, President of Maryland Show Issue. I rise in complete support of this bill. The legal analysis of the relevant statutory framework is set forth in my written testimony. The Maryland Supreme Court has directed a message to this body asking an express signal in a written opinion to address this very statute, 4-203, A1, little I, on grounds that it is a strict liability statute, does not have a mens rea requirement. And it has said that this has told the General Assembly that this is a constitutionally problematic provision and asked you to fix it. That was a 2021 decision. It's time that you fix it. This bill fixes it, and it fixes it in a comprehensive, intelligent manner. It attaches a mens rea requirement, which is common denominator to many Maryland statutes and all of the federal statutes of knowingly. That means a person has to have culpable intent. That means a mere mistake is not going to be enough to sentence a person to 5 years in prison, which is what 4-203 otherwise does. It's now the constitutional right to carry outside the home. The difference between legally carrying outside the home and not legally carrying outside the home for for an individual who's not otherwise disqualified is a presence of a permit. So what you have is a permit violation. And you're going to send somebody away for exercising a constitutional right because they don't have a permit. So otherwise, a non-disqualified person who's actually going to go to jail for a very long time simply because they didn't have the money for a permit. That makes no sense at all. I urge a favorable report.
Good afternoon. My name is Carla Mooney. I'm from St. Mary's County, District 29C. I come in representing our Women for Gun Rights and the state leader of the Armed Women of America. I stand in solidarity for both these ladies groups that number many more than myself. As a concealed carry holder, looking at this law, it gives us at least a small moniker of hope that we have taken the training we need, we follow the rules and regulations, and that we carry to protect ourselves. And that if somehow we missed something that's changed in the law, that we don't find ourselves a felon and put away in jail. There are a lot of women that I have trained and talked with that were trained by someone else that come to the Armed Women of America trainings, and they find that they didn't understand the law that was given to them in any way, shape, or form enough to say that they would ever carry beyond their own house and in their own property because they don't know what the rules are. I know law is very confusing and it's very difficult. I find that this simple adjustment here to give a little leeway to someone who made a mistake and it was a violation of their carry permit, not a felony conviction, that this should be reasonable and found appropriate in this position. I ask for a favorable report on this bill.
Good afternoon, Mr. Chairman, members of the committee. John Jocelyn speaking for 2A Maryland. Many decades ago, I was design manager for automatic sprinkler, and our office was in a very rough neighborhood. I worked a lot of overtime into the evening hours, and I got to know a man named Curtis. And Curtis was the custodian who took care of the building. He had keys to our building and a lot of other buildings. He carried a little 25 automatic. He and I got to know one another fairly well over the years. He lived on one street up from where I grew up, so we had a common bond and spoke a lot. And he expressed concern about his own safety and that he couldn't get a carry permit because this was pre-Bruin. And he was working 3 jobs to support his family, and money was very tight for this young man. And he did a very good job. And we talked about his family and so forth. Good father, hard worker. I would hate to see for the Curtises of the world that they would lose their rights simply because they were carrying a firearm without a permit. They committed no other crime, had no criminal intent, no criminal activity involved. I believe for the Curtises of the world, this is a good bill, and I would ask for a favorable report.
Thank you, Mr. Chairman. Would this bill have a positive impact upon the minority population?
Absolutely.
So if I could address that briefly, you see referenced in my written testimony a citation to the 2020 Johns Hopkins report, which says quite clearly that illegal carry by otherwise law-abiding people is common in the city of Baltimore, and they do so because they fear for their lives, and that these people are otherwise fully non-disqualified. These are all law-abiding people, but because of the circumstances beyond their control, they feel like they have to carry for their own self-protection. Don't take my word for it. Read the study. There's a citation and a link to it. So of course, these people need to be able to protect themselves. And of course, it's going to have a disproportionate favorable impact on the residents of Baltimore, which is disproportionately minority.
And very briefly, the example I gave, the young man named T that the Office of the Public Defender mentioned a few weeks ago, they mentioned him and they said he carried a firearm illegally for self-defense. Well, he probably did so without understanding the laws. And what we do in this bill is we put in for first-time offenders a fine. So there's no criminal penalties. You don't lose your rights. gives an opportunity for the court to say, you know, you've actually violated the law here. We understand you're carrying in self-defense, but you violated a criminal law. There's also a problem with the or about language. So if you're familiar with the Gun Trace Task Force, they would use that language. If a gun was in a car, they would use it to arrest everybody. So there are not only culpability standards, there are enforceability standards. There are problems in this section of code, and those are some of the things we're really looking to tighten up here a little bit. But the short answer to your question is absolutely yes. Thank you.
Thank you, Mr. Chairman. Thank you, Delegate, for bringing the bill in the panel. So to the delegate, are you saying that Curtis and T don't understand that they can't carry a firearm unless they have a permit? They don't understand this?
Curtis understood, but he was going to the old axiom of it's better to be judged by 12 than carried by 6.
But
Okay, so Curtis, he could have purchased a permit, is that correct?
Back then, he could not have qualified for it because it would not have been considered a good and substantial reason. Even if he could have afforded it financially,
Yes.
he wouldn't have been qualified to get the permit.
I understand that, but now he could probably get the permit.
He could,
Possibly.
except that now we're looking at adding about $500 worth of training.
Yeah.
So the Curtis of then today would probably be in the same boat.
Now, Curtis and T, they had their firearms, but they didn't purchase them legally, did they?
And I think the better answer to that question is maybe they were familiar with the permitting laws, and maybe they were familiar with how to get a permit, but not necessarily. I think a lot of people know that, you know, they've heard that carrying a firearm is a right, but I wouldn't say that those folks know, well, I need to get a permit and this is how I do that. And when you talk to people who handle these cases, you'll hear, you know, my client didn't really know they needed a permit to carry. They thought all they had to do was take their gun, which they legally owned, and they could do X, Y, and Z, and that's not the case.
I respect your answer. It sounds a lot like driving without insurance because you own the car, but I thank you very much.
Thank you.
Further questions for the panel? Seeing none, thank you all very much.
Thank you.
That concludes the
Thank you.
testimony for House Bill 684. Delegate Acevedo, please. Delegate Acevedo, Evelyn Frankel, Shelley Cohen Fudge. And then virtually we'll have for the favorable panel, Jonathan Roshkind and Cindy Farquhar.
It's good to be back in one of my favorite committees. Seeing one of my favorite chairs and vice chairs.
The other two people, Ms. Frankel and Ms. Cohen Fudge. That's okay. You're more.
Yeah, I think some of them are going to be virtual. Some of them.
If we see them pop in virtually, we'll. The other two people, Ms. Frankel and Mr. Rochkins, you're gonna need to fudge yourself. That's okay. You're more.
Yeah, I think some of them are going to be virtual. Some of them.
If we see them pop in virtually, we'll. The other two people, Ms. Frankel and.
Those who love the sound of their voice. That worked.
Delegate Acevedo.
Thank you very much, Mr. Chair, members of the Judiciary Committee. For the record, Delegate Gabriel Acevedo here to present House Bill 1124, the Not on Our Dime Act, which essentially would bar nonprofits in our state from receiving state dollars, but also the liability of being removed from a charitable registry if it is found to be that organization to be connected to the building of illegal settlements in the West Bank. The reason why I brought this legislation in particular is because what we are seeing, or what folks have found, is a particular connection between the United States individuals here and the purchasing of real estate in what is considered occupied Palestine or occupied West Bank. And these illegal settlements that are being built are the policies of a government whose policy right now, well, not right now, but the policy that they've been enacting for decades is in contradiction with US policy, particularly the Department of State, as well as it was recently announced that there would be sanctions for individuals who continue to not just displace Palestinians, but also the building of illegal settlements as well. And so this ensures that we as a state are aligning with our values and ensure that we are not being connected in any way with the building of illegal settlements in the West Bank, and to ensure that if nonprofits are to be found connected to that, that there are repercussions for those that do so. And this is particularly important because as a state, while we don't deal with foreign policy, and this is a bill that just ensures that we are consistent with US foreign policy, again, I would direct folks to the US Department of State policy that essentially calls the building of these settlements illegal under international law. It is also recognized by the UN as illegal settlements, and it is one of the primary policies of the current apartheid government in Israel. And so this bill ensures that nonprofit organizations that are registered in our state are not in any way connected to that. This is also particularly important because when we look at other resolutions that we've passed as a General Assembly on various international issues, we've made it a point, particularly on the Ukraine resolution around the displacement of Ukrainians and the occupation of certain parts of what is considered formerly Ukraine. And so this bill is also a matter of us being consistent and ensuring that we are not in any way connecting to the building of illegal settlements. Thank you, and I urge a favorable report on House Bill 1124, the Not on Our Dime Act.
Thank you. We'll go to Mr. Rochkins, please, virtually for 2 minutes.
Thank you. My name is Jonathan Rockhind. I'm a resident of District 43A. Thanks for this opportunity to testify in support of House Bill 1124. I'm testifying on behalf of both Baltimore and DC Metro chapters of Jewish Voice for Peace. Jewish Voice for Peace is a grassroots Jewish organization working towards freedom and justice for Palestinians and Israelis with thousands of Maryland supporters. Jewish-only settlements play a vital role in entrenching Israel's apartheid rule over millions of Palestinians who are forced to live in enclaves surrounded by checkpoints and with a separate set of rules and rights based on their ethnicity. These settlements are a violation of international law. The continued expansion of illegal settlements fuels the conflict and is intended to work against any future solution with equality, freedom, and dignity for all. By allowing the tax-exempt organizations to fund illegal settlement activities, the state of Maryland subsidizes violations of human rights and war crimes and helps fund movement in the wrong direction. During the horrific military assault on Gaza, the extreme right-wing government in Israel has also escalated violence against Palestinians and expedited settlement expansion in the occupied West Bank, and we all have a responsibility to take concrete action where we can make an impact. So it's not anti-Jewish to oppose illegal settlements. To support a future of freedom, safety, and dignity for both Palestinians and Jewish Israelis, we must do our part to stop funding or supporting settlement efforts which expand systems of supremacist control. As Jews who support Palestinian rights and lives, who want to contribute to a future of safety for all, Jewish Voice for Peace respectfully urges this committee to return a favorable report on HB 1124. Thank you for your time and attention.
Cindy Farquhar. Cindy Farquhar. Going once. Cindy Farquhar. Okay. Questions for the panel, Delegate Arakan.
Thank you, Mr. Chair. Thank you for being here, my neighbor. So I'm just like looking through oh, she's here. Do you want me to let her go?
Yeah, let's let her go.
I'll
Ms.
pause.
Farquhar, go ahead, please.
Thank you. You're wonderful. I'm Cindy Farquhar. I'm working with Baltimore Peace Action. It's a chapter of the National Peace Action Organization. We thank Delegate Acevedo for introducing this bill, which we fully support. The violent and forced displacement of Palestinians by Israeli settlers, sanctioned by the Israeli government, is clearly illegal under international humanitarian law. To quote from Article 7 of the Rome Statute of the International Criminal Court, crimes against humanity are defined and include forcible population transfer, persecution, and apartheid. Non-state actors are subject to liability for violations of international humanitarian law, including war crimes and some crimes against humanity. This includes private individuals, individuals acting as members of organizations, and potentially also legal persons, corporations, and nonprofits. Aiding and abetting liability may also be available against these actors, including legal persons. It is a little known fact that the Israeli settlement movement depends on financial support from U.S. nonprofit organizations, including organizations in Maryland. Hagit Ofran, the former head of the Settlement Watch team at Peace Now, stated that without U.S. nonprofit donations, Israeli settler organizations don't exist. Nonprofit organizations in Maryland supporting the illegal settlement enterprise are breaking U.S. tax law and should not be allowed nonprofit status. Their abuse of tax-exempt status must end, and this bill is an important step forward. Every day brings new pain and suffering to the Palestinian people: death, injury, dispossession, imprisonment, humiliation, deprivation. The list goes on. We believe that this is a critical moment, a turning point. If we do everything in our power to lawfully end Israeli occupation and apartheid, the United States can use its many tools to bring Israel in. We believe in liberty and justice for all, and that includes Palestinians. Thank you.
Thank you very much. Now we'll take questions. Delegate Eric, please.
Thank you, Mr. Chair. Round two. Okay, so I was just looking through the fiscal note, and it shows in there that you're granting power to the Attorney General. Has he issued any letter of support? Have you communicated with him at all about this? Has he asked for this?
I'm not familiar I'm not aware that he's issued any letter in support of this, and no, he has not asked me to bring this legislation.
Okay.
But some of my constituents did.
Okay, understood. And then could you tell me, do you know which nonprofits today could be impacted by this? Do you have like a list or any ballpark of who and how many?
So this is proactive legislation. That data currently doesn't exist because there isn't particular. One, there aren't many organizations or agencies that are actually gathering this data. And so this is proactive legislation to ensure that if there are any organizations who for some reason have or wish to establish a relationship with or be connected to some organization or company in building illegal settlements in the West Bank, that they understand that there are repercussions within the law, within the state code as it relates to that relationship.
Okay, so it would probably be fair to say that almost exclusively this would only impact Jewish organizations, do you think?
This is about any nonprofit within the state of Maryland that is connected to the building of illegal settlements in the West Bank. We do not specify in this legislation. We do not point out or single out any organization or a group. This is about any organization because we want to have a blanket approach here, right? Because there are a lot of folks who can be connected to the building and also the selling of real estate on what is considered occupied West Bank or Palestinian lands. We want to make sure that there's no connection whatsoever. And what we do know is that there have been and continue to be trade shows, auctions to events that are set up by real estate companies for those who are interested in purchasing real estate or land in what is considered occupied West Bank. And so again, this is inconsistent with current U.S. Department of State policy, which call the building of these settlements by the apartheid government in Israel as illegal settlements under international law. So this is about ensuring that we as a state are not just exemplifying our values, but we're also being consistent with federal government directives as well as international law.
Okay, thank you. Thank you, Mr. Chair.
Couple, if that's okay, Mr. Chair. It's always nice to see you, sir. In judiciary, we engage in a lot of hypotheticals, so I'm going to give you one. So are you at all concerned, number one, first of all, let me just say respectfully that I disagree with the characterization of you and your witnesses of Israel as an apartheid state, but that's for another debate. Maybe once we are both on the Foreign Relations Committee in Congress, we can have that debate. But anyway, the point is, my point is, I have a hypothetical for you, and that is, there are people living there. So let's say, have cerebral palsy. So let's say somebody purchases land. Somebody purchases land to open up a PT, a physical therapy clinic for people with cerebral palsy and muscular dystrophy and MS, or, name your disability. And they get some financial support to open up their PT clinic. Would these nonprofits no longer be able to help individuals with disabilities, help that woman build her clinic? Also, my second question is, and then I'll let you answer. Mr. Vladimir Putin has been accused of war crimes in Russia. The Uyghurs treat the Chinese treat the Uyghurs terribly, and Mohammed bin Salman ordered the assassination of journalist Jamal Khashoggi. So there are lots of practices that you can disagree with. And for one, I don't support the settlements. But why did you single out Israel, given that you could have introduced a not on our dime Saudi Arabia, or not on our dime Russia or China Act?
Yeah, so that was quite a bit of questions, but I'll try to answer as much as possible. If you can remind me if I don't remember any one of your questions, and I'll be sure to answer. But let me first say that words matter. And when we say that the current government in Israel is an apartheid government, that's not according to me, that's according to international law, what the United Nations also sees, as well as, I would also say, probably the most prominent country in the world that we know apartheid to be associated with, has also called and agreed with international organizations that Israel is an apartheid government. We can disagree. Happy to have that debate. But what I'm going to ensure is that whatever I say is consistent with not just international law, but what other organizations, and including the country that dealt with apartheid, also calls it. To your question, as far as other organization, I'd just like to, Delegate Kaufman, you weren't in the legislature at the time, but I'd introduced a bill around divesting regarding the treatment of the Rohingya people. And that was not only a bill that I put in, but one that we worked with agencies to ensure that Maryland as a state was divesting from any corporation that was involved in the treatment, displacement, and torture of the Rohingya people. So just to remind this body that I'm certainly very consistent in the bills that I put in, and this is not about singling out any state. It's about human rights, and it's about ensuring that we as a state are in no way connected to the violation of international law. So again, this is not about singling out any state, and I'll remind you about that bill that I'd introduced for 3 sessions. I don't think you were in the body at the time, but for folks who were here and for folks who are new, that's just knowledge for the benefit of the committee. And then lastly, as far as the other states that you had mentioned, Russia and others, and why we haven't done, I recall us passing legislation in support of Ukraine and what took place as far as land grabbing in Crimea and elsewhere. And this is what we're seeing right now. It is essentially the policy of a government that is currently in place and have been in place for decades of building illegal settlements that are viewed as illegal settlements on land that is not theirs, and essentially moving people and displacing others. It is wrong. We shouldn't be connected with it. No nonprofit should be connected with it. And this allows a form of liability for, it allows for a form of accountability for those organizations that choose to be connected in ways to the building of illegal settlements in the occupied West Bank.
Orator, but you didn't answer my hypothetical question about how whether or not somebody who's trying to build a PT clinic for kids with disabilities and get some money from an organization abroad to help build that clinic, but she builds it in the settlements because whether or not we agree with them, there are kids living there. Would she not be able to get financial support for her clinic?
That organization, and this is something that we can talk about as far as amendments, but that organization would be notified. I think, us putting this in the code, when we talk about nonprofits and nonprofits operating in the states, in our state, nonprofits are aware of laws that govern nonprofits, and this would want to be one of those in terms of nonprofits knowing what they should and should not be doing. And so if organizations, again, choose to be connected with organizations that are building illegal settlements in the West Bank, then yes, there will be repercussions for that. Nonprofits know laws and keep up with laws in terms of governing nonprofits in our states and what is considered legal and illegal. And this would be one of those governance, laws.
Mr. Chair, I strongly disagree with you, Delegate, but I appreciate your passion.
Thank you.
Thank you for your questions.
Seeing no further questions, that ends this panel on those people testifying in favor of the legislation. Thank you very much. We're going to hear now from Jay Bernstein, who's, I believe, here in opposition, and then Brad Kaufman, who's testifying virtually. Okay. Bernstein.
Yes. Hello, good evening. My name is Jay Bernstein. I urge the unfavorable report on HB 1124. Now, what is the purpose of the legislation, and why is there an entire organization devoted to enacting this type of legislation throughout the country? Is the purpose of HB 1124 to stop illegal activity in the West Bank? If that was true, this bill would not focus solely on what Israel may or may not be doing on the West Bank. If the bill was truly concerned about illegal activity in the West Bank, it would also address the fact that thousands of Palestinian terror attacks occur against Israeli civilians in the West Bank, including car ramming, shooting, stabbing, bombing of innocent men, women, and children. In the spring and summer of 2023 alone, terrorists slaughtered close to 40 Israelis in and beyond the Green Line, with more than 3,000 recorded acts of Palestinian and Arab terror. Is the purpose of HB 1124 to sanction nonprofits that fund illegal activity in the West Bank? Again, the answer is no, because if that was the case, HB 1124 would also address the over $260 billion that is sent throughout the 501c system to Hamas-aligned charities in the United States. And that includes foundations, employee giving schemes, partisan community groups. There was actually a report issued in November called Focus on Western Islamism, which is available online, which details that activity. Is the purpose of HB 1124 to address a problem that is being ignored at the federal level? No. Last month, President Biden signed an executive order sanctioning settlers who commit violence in the West Bank and freezing their assets. So what is the purpose of this bill? It's obvious. At a time when Israel is engaged in an existential struggle against a barbaric enemy, HB 1124 is part of a campaign to employ the straw man of settler violence to limit sympathy for Israel, just like the UN has done and other international forums have done as well. And I hope and pray that this assembly does not join in that effort and reports unfavorably and rejects HB 1124. Thank you.
Brad Kaufman, please.
Good afternoon. My name is Brad Kaufman. I live in District 41 and I'm an attorney. I would submit that the legislature should stick to Maryland matters and not meddle in a complex historical conflict. Moreover, this bill is discriminatory. Instead of targeting entities that have real human rights abuses like Iran and China, including the PA, the bill targets the one and only Jewish Democratic State of Israel. The bill unconscionably makes support for Israel a tortious act and would ostensibly subject Jewish organizations and its directors who support Israel to arbitrary litigation, decertification, including personal liability. There are several land disputes in the world where organizations without any repercussions support one side over another. The delegate who sponsored this bill does not subject any other group to prejudicial penalties when supporting their ancestral homeland, only the Jews. It is outrageous that we even have to consider this farcical bill. Finally, the bill itself is not even factual. Israel is not an occupier under international law. Israel is not apartheid. If you go to Hadassah Hospital in Israel, you can see Arab nurses and Arab doctors there. That doesn't look like apartheid to me. Further, the Jewish homeland in Israel existed long before any Arab country entered the planet, and Jerusalem is the undivided capital of the Jewish people for 3,000 years, and that will never change after this hearing. Israel's legitimacy will not be defined by a Maryland bill or by the anti-Israel bias of one delegate. I urge an unfavorable report because the legislature should not be endorsing hateful actions against Jewish organizations as well as Jewish directors of those organizations. And that's what this bill will do. Thank you.
Seeing none, thank you very much.
Thank
That
you.
concludes the testimony on House Bill 1124 and concludes the testimony in the House Judiciary Committee for today. We will be back tomorrow at about 1 or maybe a little after that. And we will